Hi, my lord. On the last occasion, your lordship, my lord, it was extensively matter hard and the lordship fixed for orders, my lord. I think, my lord.
We'll pass order.
Yes. Today it has come for hearing. Lordship may fix
No, it
for
has
this
come for hearing, we'll pass order.
My lord.
Either today or on Tuesday, I don't know.
Well.
If we can
Well.
do it today, we'll do it today.
Well.
Please, your lordship. My lord, I beg to mention item number 40 to 59 of this supplementary list, my lord.
420.
My lord, down
420. 420.
of court number 20, my lord, wherein a new notification has come out, and these matters are being posted before your
No, I'm only taking up, you're referring to court number 20.
20, my lord, in pursuant to this notification, wherein, my lord, the items in this supplementary list dated, my lord, 8 May, from item number 40 to 59 is being posted before your lordship, my lord, in pursuant to this notification.
Lordship, it's a part-heard matter.
These are
Pertaining to the
matters
respondent.
basically being extensively heard and part.
Have you seen the notice?
Yes, my lord. Madam, may I
The
just,
notice, there are specific matters which are shown.
along with the
Supplementary
supplementary
list.
matters, my lord, can I kindly come
No,
to
no,
the,
no, no, no.
my lord, along with matters listed in supplementary cause list, my lord. Point number 1.
Yes.
So all these matters are listed in the supplementary cause list, my lord.
Verify.
List of appropriate
Supplementary.
No.
We have
See,
only,
this court today
my lord.
is only taking up this court supplementary list. This court's list is supplementary list,
Yes, my
not
lord.
part 1. So perhaps this is what is indicated. There, along with this part 1 supplementary list, we are taking up these specific items. So we are not taking up the entire supplement. It is a supplementary list of this court.
Okay, my lord.
Okay. Okay. और फाइल आई थी ना लिस्ट में किया ना यार ये ना we'll just clarify from the bench.
Yes, my lord.
Just
I'm
wait
obliged.
for a while.
Yes, I'm obliged.
Yes.
May please, your lordship. Lordship, may I beg to listing a matter tomorrow, my lord.
1 minute. आप बेंच में खबर लीजिए एक कंफ्यूजन क्लियर कीजिए कौन सा सप्लीमेंट्री हमारा है कि उसका अभी फोन कर लीजिए yes
My lord, may I beg to list a matter tomorrow, my lord.
for what
Tomorrow for motion, my lord.
motion fresh matter
Press matter, my lord. Motion.
May I please, my lord? My lord, I beg to mention two repetitions, my lord. These are tag matters. I'm praying this to be listed on 16 for orders, my lord. I'm obliged.
Please, Lordship. Lordship, I beg to mention for listing on Tuesday, motion matter.
motion matter
Yes,
not on Tuesday
Wednesday,
Wednesday
Lordship.
Friday
Wednesday, Lordship.
Yes.
Obliged.
With consent of the other parties, I beg to mention item 8. I want an accommodation only for today. Maybe Tuesday it may come, my lord.
item 8 of court number
20, my lord.
20
Yes, my lord. If a protest is there,
for the petition
I'm petitioner, I have taken consent.
you are for the petitioner
Yes, ma'am.
and respondents you have taken consent
Consent, man. SP Chaudhuri.
request
Tuesday, my lord.
then delivered to the state after 2 weeks.
My lord.
Submitted the consent of the council to the respondents have been obtained. 2 weeks.
No, my lord. 1 week. Next week, my lord. Only for today because AK progress there is some problem here. Instructed
Or
me
after
to-
1 week. Next week.
Next week.
Maybe it's the next.
Obliged, sir.
May it please your Lordship. Lordship, I pray for listing a pending matter. Lordship. Matter is orders column.
16 May. 16 May.
May I please, your lordship, I beg to mention for motion, IA and review petition.
IAN
IA and review petition, 2 matters.
Wednesday or
Yes.
Friday. Let it be on 16.
Kindly release the matter on 13, your lordship.
13.
Yes.
13 is not possible. You have it on 16.
Sure.
Correct the date. 16.
Okay, Lordship. Okay, Lordship. Obliged.
May I please, your lordship, I beg to mention for listing of reputation, my lord, for admission column on 16, my lord.
All right, 16.
Much obliged, my lord.
May I please, your Lordship, I beg to mention for listing Lordship. Any date, Lordship, matter for
Admission,
Lordship, admission.
admission. Get it on 19.
Obliged.
Thank you.
Lordship, item number 3, 4, and 5, court
Hmm.
number 20, Lordship.
Hmm.
In these matters, I am filing my affidavit today. That is the GMC authority, Lordship. So, Lordship may take up this matter on some other.
Item 20. Sorry,
Court
court
20, Lordship.
20.
Item 3, 4, and 5
Yes.
is the petitioner.
Item 3, 4, and 5 is the request made by the Standing Council, GMC.
GMC, yes.
And the strength paper to be listed after
22nd, my lord. 22nd of May, maybe fixed, my lord.
22nd.
Yes, ma'am.
You don't want to file
In
result?
the meantime, my lord, I will file.
Fix adjournment for today on the ground that affidavit in opposition is to be filed. The counsel for the petitioner does not object to the prayer made, but submits that the matter be listed on fixed date. He prefers, he submits the matter be listed on 22nd May. Reply affidavit, if any, may be filed in the meantime. Please report.
Obliged.
May I, Lordship, bring a listing of your repetition for motion, Lordship. 14th.
For motion,
Yes, Lordship. Fresh matter.
fresh, right, 14.
Much obliged.
Not daily, somebody.
May I please, your lord. In this matter, Lordship, English counsel has some personal difficulties. He has an appointment and for eye infection in the doctor.
2017 matter. Whether, what is the status?
My lord, instructions are sought for from the petitioner side, your lordship. We have also reached out to the
Where is the order? You are not appearing.
No, lord.
Where is the order to be complied?
The order, my lord, starts at page 8. The operative portion, my lord, is at page 16, paragraph number 20. In view of the above, the impugned penalty order dated P11,005 of the disciplinary authority as well as the appellate authority's order dated 27/2/2007 are found to be legally unsustainable and the same are accordingly quashed. Hence, the respondents are directed to give all consequential service benefits to the petitioner within 8 weeks of receipt of this order.
What has happened?
Now, what has happened, my lord? If your lordship kindly takes up the affidavit in reply, the latest stand of the petitioner at paragraph number 5, my lord, is that the seniority has been restored of the petitioner, but the seniority position has not been restored in terms of his position in grade B. So that is what remains, my lord.
Why have you not done?
No, my lord, we are yet to get instructions on the matter, whether that has been complied with or not. Your lordship will grant me a short leave of maybe a week's time, my lord. We have reached out to the council since the matter pertains to.
2017 matter.
My lord, I agree, your lordship. Just 1 week's leave, I am agreed, my lord. Will satisfy this court as to whether.
All right, 13, 14.
14. I'm
Based
grateful,
on
my
14, states the counsel for the respondent. Mr. M. Sharma will complete his instructions that the status of compliance of instructions contained in the order dated so and so passed in the paper.
Deeply obliged.
14. here. The matter is hold up, the matter be listed again on 16. Showing the name of Mr. D. Board. I think. Verify. We are taking up only the matters notified, not supplementary.
Not supplementary. So I'm obliged to that.
Yes.
Lordship, on the earlier occasion, I was directed to take steps upon the respondent number 2, Lordship. Whenever I inquired in the office, they informed me that Jindi Bora is serving as a DFO. She has been recently transferred. So that's why I did not take in the same, Lordship. The present incumbent is serving Subodh Talukdar, Lordship. Lordship, in the order dated 18/8/2020, it was directed that till the decision of the DFO Lordship, the salary has been regularly paid to the petitioner, but that has not been complied with, Lordship.
Which is the order, page number 15,
Page number 9, Lordship, in the bottom,
page number.
last time, Lordship. Page number 9. The last line, Lordship. The further direction is issued that until a decision is rendered by the DFO Kamru West Division, Bamunigao, the petitioner be paid his monthly fixed salary without fail, Lordship.
So he is not received.
Yes, Lordship. I did not receive any salary.
This is which department? Forest.
Forest Department, Lordship.
Yes, Forest, Standing Council, Forest. Forest. We take it up in a way. Wait for some time. Wait for some time.
Okay, Lordship.
Lordship, may kindly pass over this matter for time being. My senior is on leagues on code number 2.
So you are here. Here. Yes.
The orders of the court.
You filed amended post title.
Yes, my lord, I have filed that.
You have taken step.
Yes, ma'am. It's loading, my lord.
So service is awaited.
Wait, my lord.
Respondent 1. Who is the respondent what?
Respondent one will be the secretary, my lord. Perhaps there is a change there also, if I'm not. Also, perhaps if the service is awaited, in the meantime, I'll try to find out if there is a change again.
This after 4 weeks. As the office reflect that the service on respondent number 1 stands awaited. Both the matters are connected.
Madam.
Both are connected
Both are same order.
after 4.
Obligation.
The respondent has neither complied with the order, my lord,
Well,
nor
I
filed
pray for-
affidavit till date, my lord. Past 3 years, my lord.
Oh, 2000.
Where is the order?
Yes, 9 page
No,
19,
sir, I
my lord,
pray
even
for
question.
3 weeks time to file my affidavit, my lord. I have got the instruction, but there are some defects in the instruction. The affidavit cannot be completed, my lord.
Para 15, my lord.
22 order.
Yes, my lord. Only notional benefit was to be given, my lord. Notional benefit of promotion, my lord.
File it by next week.
My lord.
Some
Fix
more,
it,
some more
my
time, my lord.
There is a direction to comply in 2 months.
Fine.
You are already in contempt. You drop everything, you ask your clients to drop everything and give you the instructions, otherwise we are proceeding. 2 months.
The lordship will let it be on
Next week.
26 May, my lord,
No,
26.
no, next week. Let it come next week. This is ridiculous. 22 order, 3 years,
Lordship.
and you are directed to file in
No.
2 months. We should drop contempt proceedings
Oh,
right
Lordship.
away, straight away.
Lordship will fix it on 16th, my lord.
16.
My lord.
Based
Alright.
on 16, by which date the standing council,
James, my lord.
the council for the respondent
Wow.
will obtain required instructions as to why the directions contained in the order dated so and so passed in WPT so and so was not complied, has not yet been complied. And why contempt proceedings?
May I please, Lord? Lordship, it is an impleadment petition, Lordship, for impleading the opposite parties, Lordship, as contempt note number 2 and 3, Lord.
Third, the application filed for impleadment of
Impleadment of opposite party number 1 and 2 as contempt note number 2 and 3, Lord.
the parties number 1 and 2. Where is opposite party 1 and
Opposite party, Mr. Alok Kumar. Page number, Lordship, 3, Lordship.
page number 3?
Yes, Lord.
Page number 3 only shows Jain Narlikar. Oh, IA. IA. Yes, respondents, any objection?
No, lordship.
Third council presentation, applicant, by way of this applicant, the by way of this application, applicant seeks appropriate orders from the court for arraying the opposite parties 1 and 2 as responsive number 2 and 3
2 and 3, Lord.
in the contempt petition number 576 of 2020. Submitted that these two persons are the opposite parties are also equally responsible for not complying the direction dated the order dated so and so past it. So it submitted that since the order, since the directions have not yet been complied with, the opposite parties are also fully responsible for non-compliance of the direction of the same are they are also required to be arrayed of the party. Respondent in the contempt petition. Actually, appearing for respondent 1.
Yes.
Does not object to prayer made. Voting the highest and allowed of the parties. Arrayed as respondent. Contempt number. The highest and allowed, which means noted as the opposite parties will get sufficient opportunity to file their necessary affidavit and make necessary submissions before the court. According having considered the submission court, I have developed the opposite parties were to are related responsibility with contempt. I the petitioner will file amended post title within 1 week.
Lordship,
With the history. Contempt petition is right in view of order passed in I number so and so are arrayed as respondents 2 and 3. Let's notice the two. on respondent's entry returnable in 4 weeks. Petitioner will take steps by registered post the AD within 1 week.
Noted.
Please report.
Noted. Accepting leave engagement, all other benefits he has been given. Let him take instruction on that.
Very please, Your Lordship. Lordship, DPO and GPO has already been issued
Yes, we have received.
from our side, Your Lordship, regarding arrears, Lordship, that will be looked after by the department, Your Lordship.
I will take instruction on that.
And leave engagement.
Mr. P.D. Das, London City Council, assisted by Mr. Lota, A. Lota, submits that except for leave encashment and
Leave
area,
engagement, yes, area.
area salary, all other benefits have been received by the respondent. By the petitioner in terms of the direction contained in the order dated so passed in the so Mr. C. Sharma, London Council representing 4, 5 and 6. 4, 5 respondent, 4, 5 and 6. Praise for an is granted 3 weeks time to complete instructions for the release of the other outstanding dues. Mr. A. Boro,
R. Boro.
R. Boro appears for accountant.
Response number 9. Oblige, Your Lordship.
Complied.
My lord, because of non-submission of NOCs, my lord.
Senior is late and another.
Senior is like you are there, you have the brief. Yes, what is not complied with?
My lord, actually what happened, my lord? There were 8 next of kins of the wife of the deceased, my lord. Thereafter, therefore, my lord, the son of the deceased, my lord, he claimed, but my lord, there are other daughters also. From them, my lord, NOC is mandatory, my lord. That was not submitted. That is why it was not complied, my lord.
So who is the petitioner?
Petitioner is the son of the deceased, my lord. Deceased employee. Already mother has already expired.
You want NOC?
Yes, my lord. Because there are 8 next of kins, my lord. Area for area pension, my lord.
The order amended because in the order nothing is there. Direction of the court is to release the amount.
Yes, my lord. But
If according to you, there are
in the office itself, it was submitted, my lord. There are 8 claims, my lord.
have you filed anything to show?
My lord, I have received the instruction. I will file, my lord. File affidavit.
Counsel for the respondent submits that you'd like to file the affidavit in opposition as the directions contained in dated so and so contained in the order dated so and so passed in the so and so. Then the process of any implemented, however, it is seen that petitioner, besides the petitioner,
There are 7 other
7 other
next of
legal
kins.
years of the father of the petitioner who was an employee of the respondent department. Therefore, the relevant documents, including NOCs, are required to be submitted by the other years, which has not yet been done. The stop view of the prayer made had to be listed after 2 weeks. MS so and so represents the petition.
But in this matter, I need 2 weeks further time, my lord. Instruction not received, my lord.
Mr. S. Dotto, counsel for the respondent, prays for further 2 weeks time to complete his instruction.
Right.
MS.
A. Begum.
Take on. Highly obliged.
Yeah, please, Your Lordship. Lordship, in this matter, office note dated 3/5/25 states that neither ID card nor unserved notice has been received back. So any short date may be given, Lordship.
Office note dated 3/5/2025 shows that ID card service is awaited on respondent one. Matter therefore be deferred after 3 weeks.
Any date may be given, Lordship.
Noted. The service be completed. After service is complete,
If we get a date, then Lordship will be able to.
you pursue it with the registry.
Obliged.
Okay, so respondent number 3, my lord. We filed our affidavit.
You have filed your affidavit. What is the direction? Which order?
It.
Where is the order?
Yes, my lord. It starts from my lord 22, my lord, 2021. Direction, my lord, is fine. At page 50, man. 50 is the direction. Page 50, paragraph 1921. It will be, my lord, respondent number 2 who will have to implement, my lord. The respondent number 3,
You are for?
respondent number 3, my lord, drug control act.
Huh?
We do not have anything to do with regard to extension and regularization of services, my lord, under 3.
Respondent number 3 in which writ petition? I'm sorry.
In the contempt, in the contempt.
Contempt case number 560 of 24. Pankaj Kakoti.
Yes, yes.
In the contempt, my lord, I appear for respondent number 3, my lord.
I am appearing for respondent number
One.
one, my lord. One is the Commissioner and Secretary of the Personnel Department. My instruction is that Personnel Department has no role at this stage, my lord. Because the respondent number 2, he is an employee of Health and Family
Who
Welfare.
appears for the respondent 3?
Three I am appearing, man.
3 you are appearing. Drugs control.
My lord.
And then
Well, we have annexed a letter from the commissioner of the drug controller, my lord. Well, that says, my lord, we
you
do not
filed
have.
your affidavit.
Yes, ma'am, we have filed.
What does it say?
Well, we do not have any role in with regard to extension of services under 3F of the regulation. ma'am.
Who has the role?
It is the administrative department, that is the health department. Will have.
Health department.
Yes.
Who appears for
Respondent
health?
number 2.
Who appears for health?
D DECA is reflected in the cause list. ma'am. D DECA number 12.
M Dhor. Who is Mrs. M Dhor?
D DECA is there. ma'am. In the cause list, ma'am, some D DECA has been
No, some Mrs. M Dhor was had accepted notice.
D DECA to health.
None appears for the petitioner. D Nath appears for respondent 1. Neil appears for respondent 3. Mr. Nath submits that direction is contained in the order, judgment and order dated to the fasting the people are required to be complied with, are required to be carried out by the respondent number 2. Respondent 1 has no role in the matter. So, similar submission made by Mr. Munir. by the last order dated 3/4/2025, name of MS M. Thor. He showing as the council for respondent was permitted previous time to pay the charge. However, he said that the council is not present. Neither is the government present. The such circumstance, the court considers it appropriate to refer the matter instead after 1 week. Showing the names of the registry will ensure names of all councils that are shown in the post list. This according. Service report for respondent 1 and 2 is awaited.
Yes, yes, to be
As per office note dated by Mr. A. Ahmed, appears after 3 weeks.
I may be allowed to take.
Press step. Since at the prayer of the council for the petition, I permitted to take press steps on 1 and 2. I registered post AD as well as usual courts. This
Okay.
according.
May please, Your Honor, I'm appearing for response 2 and 3, my lord. So 3 weeks time may be given to file our affidavit.
I'm appears for the petitioner, Mr. A. Sharma, appears for respondent 2 and 3.
Yes, ma'am.
He prays for 3 weeks time to file a affidavit. Prayer made is allowed, list after 3 weeks. IA has been filed for condonation of delay of 158. And appeared for the petitioner applicant, and the matter was called up last on 6/1/2025. Today also, matter is called up purely for the ends of justice, matter shall be heard to be listed after.
Service is awaited on the sole respondent.
Mr. R. Madhukar, if you service on respondent, its whole respondent in the way. It's after 3 weeks.
Obliged, madam.
Doctor, in this matter, I am appearing for the respondents, Doctor, all the respondents. Doctor, what I have been informed, Lordship, though I have not received any written instruction. They are complying with the order passed by the Honorable Court, Doctor.
You furnish it before the court.
Yes, Lordship. On the next date, Lordship, I will place the written instruction.
None appears to the petitioner on call. Mr. Ayok, counsel. Nayak, appearing for all.
Yes, Doctor. One query.
All the respondents. Submit that on oral instructions, he's been informed that the order has been complied.
They are complying with the
He is in the process of being complied. He submits that he would like to complete his instructions in the matter for 3 weeks time. Let the matter be listed again after 3 weeks, by which time the status of compliance of the directives contained in the order dated passed in WPC so and so, he placed it to the court.
law.
Please record it.
May I please, Lordship? My lord, can we see the office note, my lord? Steps were taken, my lord, but office note dated 5/5/25, my lord. Neither the ID card nor the answer notice has been returned.
As per office report, as per office note, service report is awaited on sole response. Mr. PC Day appears for the petition. Place this matter after 3 weeks.
My senior is on leg, my lord. It will be taken up for some time.
Well, here I am appearing for response number 2, but I have filed the Uttalatnama. I need some time for filing the affidavit.
Your name?
B. Sakya, my lord. B. Sakya.
Mr. B. Sakya appears for the petitioner. Mr. D. Nath, counsel appearing for respondent.
2.
2 submits that he would like to file his affidavit, complete his instructions and file affidavit, and praise for 2 weeks' time.
I pray for 2 weeks.
Right. Mr. Goswami?
For 1 and 3, Lordship, we received an instruction, Lordship.
What effect? Order compliant.
It is processed to comply.
Very well, you complete your instruction.
Look.
Similar prayer is also made by appearing for respondent.
1 and 3.
1 and accordingly matters that differ with the meetings. Within the applicant. Right. That's
This application has been filed for impleadment, Lord. As response number 3 and 4. We have communicated the copy of the order also, Lordship. Lordship will find in Annexure 8, page 8, Annexure 1, page 8, Lordship.
Party number 3 and 4. Namely, Virendra Mittal and Victor Namkap. Respondent number 313. This application that the direct content paper party okay, right. So the public has been made submitted that they were respondents earlier.
No, Lord.
Then
Lordship, during the pendency of that case, Lordship, earlier respondent number 1 and 2 has relieved, Lordship. That is why I will say it.
submitted that
I've stated in paragraph 3, my Lord.
respondent 1 and 3.
1 and 2, my Lord.
Huh?
1 and 2, earlier respondent 1 and 2.
What are the names?
Names, Lordship, that Lordship, Virendra Mittal, Lordship, and Borsing Longti. Paragraph 3, my Lord.
You're getting, look into your course title, there is utter confusion. The course title?
Lordship.
Course title of the IA.
Yes, sir.
Number 1, page number 1 is the petitioner. Number 2 are.
Sorry, Lordship. M.S. Manibhandan, Lordship. Yes, sir.
It submitted that the respondent had debited their offices. Consequently, the present incumbents are required to carry the fund for direct. Mr. You're appearing.
My lord, I'll be appearing for the respondent 1, my lord, but I was for the former one. So when the notices go, I'll appear. Appearing.
They submitted that the earlier incumbent had debited office from their offices and new incumbents have joined be allowed. Permitting of the parties wanted to as the I allowed them to participate as the party. For their treatment, even at the representative by I developed the party for partner the product of party responsible right? You order it with it is the picture that product of our very party directed by the ticket by
In last occasion, the petition was not present, and as far as my instruction is representative dispose of a lordship. His representation, which was
they have
dated.
received something.
This is in the last order dated lordship, if I may. Lordship, kindly peruse order dated 13/10/2023, your lordship. In fact, the petition will also take fresh steps on response number 2, your lordship. I'm present response number 1.
Order dated 30/10/2023 reflects the petitioner and the request for permitted take fresh step on response number
2.
So, office note dated 25/3/2025 shows that fresh steps were not taken on respondent. Right. The last date is 28/3/2025. None had represented. We also such a circumstance, the court does not wish to proceed any further. The contempt petition. Mr. R.R. Gogoi appears for the contempt and no notice is issued and report.
Obliged, lordship.
Mr. Goswami will just pull up the few items that is placed before the court in respect of court number 20. We'll just complete it, not too many matters. Then we'll call up him.
No
It will take some time.
No problem.
Mr. Nayak?
Yes,
We'll
Doctor.
call it up after the time.
After completing the, yes, Doctor.
May I please selection, my lord.
Yeah.
My lord, an advertisement was issued, my lord, in the year 2022, my lord, to fill up two categories of posts. One is administrative officer, another is revenue sales server, my lord. And several dates were sought by the government council to get the instruction. And so far as the instruction that I have, my lord, these two categories of posts, my lord, have not been filled up, my lord, till date, my lord. That's why I'm paying before your lordship, my lord, for the issuance of the direction to the respondent authorities, my lord, especially to the respondent number 2, the district commissioner, to fill up the post, my lord.
Yes, respondent.
Lordship. Updated instructions are awaited, Lordship. As on the last occasion, we have submitted, Lordship, as per our instruction, that file is not pressable, Lordship. Some more time is required, Lordship.
All right, heard a council. You submitted that. In any view of the matter, till 15, nothing can happen. Till the panchayat elections are going.
Right.
Code of conduct. is there.
Time frame may kindly be given if possible, my lord. That they may
You
fill up
are
the post.
seeking a direction to proceed with the advertisement. What is your prayer?
My lord, since I was one of the applicants, my lord, a direction may kindly be issued to the district commissioner, my lord, that he may fill up the post, my lord, accordingly.
How? By selection process has started.
Selection process has not been started.
That is what we are saying, that direction
Yes.
cannot be made effective till 15.
Then, my lord, that the case may be listed after 15.
Path appears for the
Eight are looked at.
data looker for
For
the
2 and 3,
all
Lordship.
the respondents.
2 and 3, Lordship.
2 and 3.
Respondent number 1 is GAD.
It's submitted that instructions are awaited as presently panchayat elections in the state are underway. We can therefore submit that the 2 weeks time be granted completed instructions. Accordingly, matter said paper to be listed in the last 4th week of May. May.
My lord, that date may kindly be given if possible.
Date 28th
My lord,
of
deeply,
Deeply obliged, Lordship. May I please the law? Last occasion, they took time, last 3 or 4 occasions, Lordship. They're taking.
Lordship, it was prepared and everything done, Lordship, but due to election, Lordship, they were engaged there. Lordship, they have sought for a recommendation of 1 week, Lordship.
But 1 week election will not be over.
It will be over, Lordship.
Be over.
Yes.
Mr. Kanungo, if it's for the receptioner, and the charging or the cabinet. Submit their affidavit is ready.
Is ready, Lordship.
However, DOP ensuing panchayat election underway in the state. Further 1 week's time be granted. Further 2 weeks time be granted. I'll be accordingly, let the matter be listed again. 26.
Lordship.
Deeply.
Okay.
Obliged, your Lordship.
the affidavit in reply has been filed today, is being filed today, will be taken up on Thursday.
Mr. R. Mazumdar, Bharat Council, applicant submit their affidavit in reply by the affidavit filed by the accordingly. However, the same is not available. It's before.
No, I am filing it today.
You are filing it.
My lord, yes.
He's being filed. He submits that he is filing the affidavit in reply to it. Accordingly,
Lordship on 14.
matter stands referred to be listed again.
On 14, Lordship. 14, Lordship.
15th is the hearing day, my lord. My technical.
Why 14 or 15?
I'll leave it to you,
Because
Lordship.
there is an ongoing recruitment process where we had sought for an intent protection. I and the
No,
recruitment
there is something to do with your extension, is it?
extension, my lord, they have granted till May.
Till May.
They have granted the extension till May. But they're proceeding with the recruitment process.
22nd? 22nd? It's on 22nd.
Objection.
Some reports were to be produced.
Lordship.
Let none appears to the petition as also the learned petitioner lady or a charter developer were required to produce the reports pertaining to the department of the listed matter again on 15,
Lordship 15.5. Lordship.
55.
I will inform Lord. I am appearing on behalf of
Chachi appears for
respondent number 3, Lordship.
please inform Mr.
4.
Ward.
Lordship. As well. Deeply obliged.
Appears the method set. Hold up, please. Please start.
This is your lordship. Your lordship, can it be taken up after some time, lordship? The senior counsel, as we speak, is making his way.
After some time.
Yes, lordship.
Okay. After some time.
My lord, I also have a matter in the next court number 9. It will be taken after some time.
We have no matter, we'll take it up.
My lord, but I am here, my lord.
After some time. We'll call up after some time.
Highly obliged.
I'll be there, but my lord.
Yes, your senior is here. Yes, Mr. Das.
Not take much time, madam. This is Khadi Board employees. Since inception, they are getting the benefit of the pay commission. But for the 7 pay commission, starting from 2017, they have been denied. Now, I have made a small notes. Are provided. Now, your lordship will kindly see. We came to, the cabinet decision was taken at page 33. Page 33.
Page 33.
Sorry, madam.
Yes, it's an extract of the cabinet.
Yes. But as this was not, my lord, approved. Your lordship has seen that, approved. As this was not acted upon, so we came before this honorable court. And this court ultimately, my lord, page 13, my lord, page 50, my lord.
50.
50. Last part, my lord. The present petition has been filed by the Khadi Board, page 51.
Yes.
On behalf of the employees of the Khadi Board, it is the stand of the petitioners that the employees of the board have been granted revised pay scales in terms of the Rule 2000, ROP Rule 2010, which has been clearly indicated in the office order dated so and so. Thereafter, after revision of pay in the year 2017 as per the ROP rules, has been implemented for all the employees of the government of Assam. The employees of the Khadi Board claim that they are also entitled to the benefit in terms of ROP 2017, which was favorably considered by the authorities in presence of the Honorable Chief Minister as reflected in the minutes of meeting dated 21/8/2018. That your lordship will get it at page 39. Whereby a decision was taken that a Handloom and Textiles Sericulture Department will examine the matter of revised pay of the employees of the board and take necessary steps in that regard as per existing rules. Thereafter, the matter was further processed and in fact the Handloom and Textile Sericulture Department has allocated certain amount for payment of the revised pay to the employees of the board after the same was approved by the cabinet as indicated in the official letter dated 2019. It has been submitted by the council for the petitioner that since the cabinet approval is not forthcoming, the said amount, though allocated and earmarked, has not been released for the employees of the board. In that view of the matter, this court is of the view that the present petition can be disposed of with a direction to the respondent authority to examine the claim of the petitioner in the light of the decision taken by the authorities in the meeting dated 2018. That 2018 meeting is to page 39. Your lordship once again, lordship will kindly see. This is the meeting. Serial number 3.
Page number?
39.
Yes.
The 3, my lord, last below.
Yes.
The chairman Khadi Board stated that all the state government employees and some other state government organizations are enjoying the benefit of revised pay of the 7th pay commission, but the employees of the Khadi Board are still drawing their salary as per the 6th pay commission. Since the pay and allowances and creation of the post of the Khadi Board are done with the approval of the government and for non-approval of the revised pay of the government, in Handloom and Textile Sericulture Department, the employees of the board have not been paid the revised pay. Now, number 3, my lord. The Handloom and Textile and Sericulture Department will examine the matter of revised pay of the employees of Khadi Board and take necessary steps in this regard as per the existing rule. Now, after the High Court order, they passed a speaking order that your lordship will get it at page 53. Now, speaking order says, my lord, that they are first, my lord, may I just read this? This is important. Second paragraph, my lord. In the matter, it may be recalled that with regard to the revision of pay scales to the employees of the Assam Khadi Board, a proposal was sent by the Khadi Board to the Department of Handloom and Textiles on 2018. Since the matter relating to revision of pay scales, making budget provision, grants in aid for the same falls under the jurisdictions of the Finance Department, the proposal was sent to the Finance Department for approval. Now, the Finance Department in the matter, by its endorsement dated, had communicated as follows. Finance Department had no objection to the Cabinet Memorandum for revision of pay scales to the employees of the Assam Khadi and Village Board as proposed by the department subject to the following conditions. Now, number 1 condition is that the administrative department ensures that the conditions laid down in the notification dated 2017/1/2018 is followed. that is at page 62. My lord, your lordship may kindly see page 62. Page 62, my lord. This your lordship will kindly see in exercise of power conferred by the proviso to Article 309 of the Constitution of India, Governor of Assam is pleased to order that the individual state level public enterprise, they have taken the Khadi Board as a public enterprise, may adopt the provisions regarding revisions of pay scales, allowances and pay area pay as prescribed to state government employees as per the Assam Service Rules 2017 published in extraordinary issues of the Assam Gazette so and so. The Board of Directors of the SLP state level public enterprise shall decide to adopt the provisions regarding revision of pay scales, allowances and payment of area pay as per the Assam Services Rules 2017. After examining the detailed financial involvement regarding pay revision. Pay revision is to be followed with the approval of the administrative department concerned only after the board of directors agree that the SLP concerned has adequate financial resources to meet the expenditure for payment of the revised pay. The PSC having let net profit for the last 3 consecutive years up to 2016. Now page 30 may kindly be seen. They have taken the board as a public sector undertaking. That is not correct because public sector undertaking has been withdrawn in page 30, your lordship will kindly see. This is non-application of mine. No? 30. Yes, 30. With reference to the subject cited above 2002, I am directed to inform you that the Public Enterprise Department is viewed that since Assam Khadi Board Village India has predominantly a developmental and promotional role, the enterprise has been delisted from the public enterprise. So this was done in the year 2002. Now this public speaking order says, this is they have taken the Khadi Board as the public sector undertaking. So therefore they have proceeded in the matter. Now again coming to page 62, they have taken them to be a public sector undertaking and proceeded in the matter. Without totally ignoring page 13.
Totally ignoring
page 30.
30.
30, which
You
is
are
delisted.
no longer a public sector undertaking.
Not a public, it's a developmental. We do developmental and
Then
promotional role.
Who is to give you?
Everything is by the government. Because I'll come to that, my lord. Everything, my lord, even the salary, promotion.
You are not a department of the government.
I'm a part. It's a board, and it is like a department of the for all purpose. It's a department.
No, but then there has to be where is the order creating?
Well, I'll come to that, my lord. That order, they have an act. They have an act. So this is what the speaking order says, and ultimately, my lord, what I want to show, my lord, since inception of the board in 64, they are getting the benefit of the order. But for the 2017 benefit, they are saying that you are a public sector undertaking, unless you have your own income, you will not get the benefit of the public sector undertaking. And the money for the purpose of giving the benefit of 2017 ROP, it has been given to the board. It has been given to the board, only the approval has not been given by the handloom department. So therefore, it has come, it has gone. It has come, it has gone. For last 3-4 years, in the budgetary allocation, the board has taken the amount in the budget. It has been sent to the government. Government has approved. Money has come to the board, but it has not been allowed to be utilized. So therefore, the money has gone back. So this is the position as on today. So I'll now what they say, my lord. Finance affidavit. Now, Finance affidavit, your lordship will get it at page 115. Well, I made a small note. Wait. A small note is there. This is including the petitioner affidavit in opposition.
Yes.
Affidavit in opposition and all matter. Your lordship will kindly see flag A.
Flag A.
Flag A. This is the provision in the Khadi Board Act. And Act is also, I have enclosed, my lord, that is at B. My lord, Khadi Board Act, my lord, I am just showing from the note. Note, my lord, the government is to appoint an officer of its own to act as CEO. My lord, I can take your lordship to the provision of section 4.
No, not necessarily.
Yes, the note will do. Then 10H, your lordship will kindly. All rights, obligations, and liabilities, including liability under any contract, shall be the rights, obligations, and liabilities of the state government. Now, the budget has to be approved by the state government, section 20. And section 11 is, my lord, illustrates the functions of the board. Section 18 says, my lord, provides that the board shall.
10H2.
Yes. All rights, obligations, and liabilities, including.
H2C is a part of 10H.
Yes.
10H is the power to dissolve.
Yes.
So once you dissolve the.
Then only, yes. Then only all
then only
liabilities.
of the liabilities.
Yes,
not
all
otherwise.
liabilities will come only after, my lord. If
Dissolution.
if it is dissolved, everything will come under the
That
government.
will
takes
not perhaps mean that all responsibilities, rights will be of the state government.
No,
Even if
once
you
it is dissolved, all these liabilities, my lord, public rights, obligations, and liabilities. will
only
be
after
with the state
dissolution.
government. Because the board is totally it is functioned by the government of. It is the officers that are created by the government. Officers are appointed, chairman is appointed, chairman has been given all benefit of cards, etc., a lot of other things by the government of Assam. Then the section 20, your lordship will tell you, see, the budget has to be 2021, budget has to be approved by the state government. Provides, and all this with this approval, my lord, since inception, my lord, they have been giving the benefit of the ROP since inception. And therefore, my lord, why they are not giving in the year 2017? They are saying that no, you'll have to have your own fund. Now, section 22 provides provision for supplementary budget as approved by the state government. So that budget provision, my lord. The annual report of the board has to be laid before the state legislature. The audit of the board shall be audited by the AG of Assam. The board is required to follow the directions of the state government.
But the section 18 says that all funds.
Yeah, board shall have its own fund. So that is what they are saying. Own fund, and they can also accept grants. So the finance department is harping mainly on section 18, saying that board has to manage the fund from their own source. But in practice, but from the provisions of approval of the budget, etc., it is seen, even the salary, etc., are paid by the government of Assam. Budget is placed before the government of Assam, and government of Assam approves. Now, and last section, I'll just point out one, page 35. Page 35, my lord, in the petition, late petition. This was the approval for 2010 budget, ROP, benefit of the ROP. Ajay also got in.
Yes.
Page 35. I am directed to say that the government of Assam is pleased to allow the implementation of the revised pay structure as per ROP Rule 2010 to the employees of AKB who are on roll as on 2006. So now number 5, the payment of area is subject to the availability of fund in the budget. 2011-12 under appropriate of head of account duly sanctioned and released by the government. Number 7, AKB will not create any post in the board without the prior approval of the finance department. This is 2012. This is what we got. This is in respect of the 2010 ROP. Now 1998 ROP, page 135. grant of revised, as your lordship got it, grant of revised scale of pay to the employees of the board, by letter dated 2002. In inviting a reference to a letter on the aforesaid, I am directed to say that the governor of Assam is pleased to allow the benefit of the Assam ROP to 1998 to the officers and staff of Assam Khadi Board provisionally on the following condition. The last condition shall bear last, my lord, 3. The board shall bear the entire financial liabilities arising out of this division of pay out of their own budget. That means they will have to show it in their budget, which will be approved by the government, and government will allocate. So this is 98. Similarly, my lord, from 1964 onwards, these are the papers which are available for these two 1998 ROP and 2010. Liabilities arising out of the revision of pay out of their own budget, provision including the usual provisions for grant in aid available payable by the state government, and no more for payment of any additional fund shall be entertained by the government under any circumstance. So here also the similar conditions are there that you will have to meet it from your own budget. So therefore, and budget means we prepare it in the budget. And your lordship will kindly see the affidavit which has been filed by the department, my lord. Department. Before that, I think I should take your lordship to the finance department affidavit, page 115, which is important. Page 115.
One five.
5.
Yes.
11113, then 152. Yes. Okay. Yes, page 98. This is additional chief secretary. It is for the final. This is- I'm sorry, my some pagination problems were there. And by the finance department. 115, where is it? 84, 84. Certificate in reply. Yes, ma'am. My lord, para 4-5, I'll read that, my lord. Para 4117. My lord, that as regard the statements made in paragraph 2 of the repetition, deponent begs to state that the Khadi Board is a creation of the statute and regulated by the Act. The board receives grants in it from the state government from where the salaries of its employees are paid. As per, this is an accepted fact, my lord. We do not earn any money. As per section 18 of the Act, the board shall have its own fund and all receipts of the board shall be credited thereto and all payments by the board shall be met therefrom. So they have annexed, my lord, Annexure A, only the provisions of section 18 and other provisions they have just ignored.
What is the function of the board?
Whatever developmental activities is provided by the government, my lord, they do that.
What is the nature of what?
Promoting Khadis, my lord. Khadis, then some village activities.
running certain, you are selling certain products.
Products also, my lord. The board was established, I'm just
Then
reading, my
why do
lord,
you say that
page
there is no
11.
income?
My lord.
So you said that board does not have its own income.
No, that is the income which comes, my lord, from the sale of the product. That doesn't meet anything for the salaries of the board. But they sell some products like honey, Khadi product, and whatever governmental, nowadays they are implementing the scheme provided by the government. The activities has come. So, but that doesn't mean that they are going to meet the salaries and huge interest. Even the chairman has got a car, CEO has got a car, they get government salaries. These things they cannot provide, the board cannot provide with the minimum income. So therefore, my lord, they have to create a budget, and budget has to be sent to the government and government approve. And accordingly, my lord, they have been getting the salaries from the government with the approval of the budget. And here also, my lord, budget has been approved, amount has been given, but the utility, my lord, that sanction has not been given by the department. So that is the reason, my lord, money has come to the board, they are unable to utilize. But for the all other occasions, they have been given the benefit of the ROP. And there is no reason, my lord, why this 2017 ROP benefit should not be given. I'll provide a judgment also. Purpose of the board has been, I have given it in, but that is there. In the judgment, it will be reflected. I'll show a judgment from the Odisha High Court. Now, paragraph, page 117 again, my lord. It is not denied that the board is not receiving grants from the government of Assam. Paragraph 117. That as regard to the statements made in paragraph 3 of the writ petition, the deponent begs to state that Assam Khadi Board receives grants in aid from the state government from where the salaries of its employees are paid. They accept this. As per the Act, Section 2018, the board shall have its own fund and all receipts of the board shall be credited thereto and all payments by the board shall be made there. So why they are saying this, I don't understand. They are accepting that the salaries are being paid by the government. And not only that, my lord, all other benefits. They follow Assam disciplinary appeal rules also. That as regard paragraph 6, your lordship may skip, my lord. Paragraph 7, that as regards the statement made in paragraph 5 of the writ petition, the deponent begs to state that Handloom and Textile Sericulture Department, by letter dated 2003, had allowed revision of pay to the employees of the Khadi Board as per ROP 1998, with the condition, amongst others, that the AKB shall bear the entire financial liabilities arising out of the revision of pay, and no additional fund shall be provided by the government. But budget they have approved and they got it. Again in 2011, after publication of the ROP 2010, Handloom and Textile Department had moved a cabinet memorandum for grant of revised pay to the employees of the board as per ROP 2010. Finance Department had conveyed no objections subject to the condition that no post would be created in Khadi Board without the prior approval of the Finance Department, and board would be amended accordingly. Act would be amended accordingly. Cabinet had approved revised pay to the employees of Assam Khadi Industries Board as per ROP 2010. So they are accepting it, my lord. Here also 2017 they have approved it. They have sent the money, but the department, for the reason best known, they have not given the sanction order. Now paragraph 8, your lordship may skip. Then paragraph 9, that as regard the statements made in paragraph 7, the deponent begs to state that as per the recommendation of the 7 Assam Service Rules 2017 was published in 2017, which was effective from 2016. ROP 2017 deals with pay and allowances of regular state government employees. It is clearly stated that Rule 2 and so that unless specifically extended under express order of the government, this rule shall not be applied to officers and staff of the public undertaking of the Assam employees, Assam government employees of the government registered societies such as missions, etc. Here, your lordship will only see that that order, that this is in respect of the public sector undertaking, which, my lord, the petitioner has been already deleted from it. I think they are referring to page 136. Page 136. In exercise of power conferred by the provisions of 309 of the Constitution of India, the Governor of Assam is here to please to make the following rules. Application of the rule, short as these rules may be called the Assam Service 2017. Application of the rules, save as otherwise provided by or under these rules shall apply to all employees appointed to services or posts in connection with the affairs of the state, Assam, and are under the rule-making control of the Governor of Assam. We fall here, number one. Number two, unless specifically extended under express order of the government, this rule shall not apply to the members of All India Service, Judicial Service, because they are all there. Yes.
Why are we hearing the matter today? There is an order earlier.
Yeah.
We listed in part 2 hearing list.
Well, this matter has to be heard finally matter.
We have to hear it.
Yeah.
Hear.
It is from part 2, it is upgraded matter. We made a mention.
What is your prayer now? What
Not
is the interference you want from the court?
This ultimately, my lord, they have to be given the what they should be.
There is a prayer for setting aside Annexure 12.
Yeah.
Annexure 12.
So 14, I think.
Your prayer says it is Annexure 12.
24/1/22 order.
It is annexure 14.
Annexure 14.
Yeah.
That's speaking order.
It is corrected then in the repetition matter.
Speaking order by the department.
Yes. It's new for the thing. Amount cabinet has already approved. Now the speaking order.
What was the direction? Let us go back to the direction of the court.
Direction of the court is at page, my lord, because this was after the approval of the cabinet, page 25.
Only to examine your claim.
50.
In the direction was to examine your
Yes,
claim.
yes. Then the speaking order was passed. This is without any application of mine. They have thought it, my lord, this is a public sector undertaking. They have totally ignored that here this board has been deleted from the public sector undertaking. As far back in the year 2002. This 53 order, page 53 order. It also says, my lord, accounts has to be.
Yeah.
Accounts has to be examined on urgent basis. That also it says, page 53, my lord. Your lordship will kindly see, I'll just read. Page 53. This is the impugn order passed after the High Court order, my lord. My lord, middle portion from the 1, 2, 3, 4. 4, my lord, after about 4 paragraphs, as per report of the Accountant General, your lordship has got it.
Yes.
Yes. As per report of the Accountant General, the accounts of the Assam Khadi and Village Board was not duly audited by the competent authorities since 12 years with effect from 2006-7 onwards. Copy of which is enclosed here with a flag A. As such, the present financial condition of the Assam Board, the Khadi Board, is not known, and on how board is able to propose the revised pay scale as per the 7th recommendation to the officers and staff from their own sources. Handloom and Textile Department is therefore requested to consult with the government advocate and submit an affidavit in the court that before giving revised pay, as per the seventh pay recommendation, the accounts of the board should be examined. So now they are saying the accounts is not clear. So it should be examined by the competent authority on an urgent basis. And after that, authority may decide on granting their pay revision. So this is what they say. The reply of the finance department was communicated to the board. However, on request of the board, the matter was again taken up by the finance department on 2020. The finance department, however, reiterated its earlier views by their endorsement dated 2020. It may be mentioned that pursuant to this, also the Handloom and Textile Sericulture Department on two more times have taken up the issue with the finance department. Their latest endorsement so and so is below. It has been further learned that up-to-date audit has not been conducted as yet by the competent authority. In the absence of up-to-date audit report, it will not be possible to gauge the financial condition of the board as to whether the board will be able to pay the revised pay rules 2017 to their officers and staff from their own source. Until and unless the financial condition of the board is strong, only then the board will be able to meet the additional. So it is going hither and thither. First they said unless the accounts are completed, we cannot go. Before release of the benefit, they will have to complete the revised pay. Now, page 54, in view of the above, after about 4 lines, you are therefore requested to kindly comply with the directions of the finance department. After fulfilling the conditions stipulated by the finance department, you may submit a proposal for revised pay scale for consideration of the finance department. Now, the affidavit filed by the CEO, my lord, chief executive officers of the board, your lordship may kindly see, my lord, page starts from page 220, my lord. 220. Your lordship.
Yeah.
Here, 220, paragraph 5, that the deponent begs to submit that in the board's 175th meeting held on 2017, the issue with regard to implementation of ROP 17 was placed before the board, and the secretary, Handloom and Sericulture, informed that the proposal for implementation of the 2017 with regard to the board's employees has already been pursued in the government level. The director, Khadi and Village Industries Commission, opined that the board's employees are entitled to get the same benefit at par with other state government employees. Now, next paragraph, that the deponent begs to state that the notification dated 2018, which they are saying, my lord, is not applicable to Assam Khadi and Village Industries Board, as the board has been already delisted from the list of public sector enterprise by memo dated 2002. That is at page 30, which I have shown. And the notification dated was 2018 was meant by for only state level public enterprise. It is also stated that the board since its inception has never created any post so far without the approval of the finance department, and further that the revision of pay since inception to sixth pay commission, that the ROP 2010 has been allowed for the employees of the board, and the same has been continued to be received on fulfilling the conditions set by the Handloom and Textile Sericulture Department. Now, next paragraph, my lord, that in the meeting held on 2018 to discuss various issues relating to the Assam Khadi and Village Industries Board, wherein the Honorable Chief Minister Assam was a part of the members present in the meeting, decided that the Handloom and Textile Department shall examine the matter of revision of pay of the employees of the board and take necessary steps for the same as per the existing rule. That it is submitted that since inception, the employees of the board have been enjoying the benefit of the salary, dearness allowances, and revised pay scale, etc., at par with that of the state government employees, and the employees have been receiving revision of pay as per ROP 2010 as directed by so and so. The funds required for such purpose were sanctioned and released by the government through state budgets as grants in aid under the head so and so. The board does not have any earning from its own source. All committed expenditures, etc., that is salary, etc., are being incurred from the budget provision of the.
What is the status of other boards.
But one board I have got, my lord, this Orissa. Orissa board.
No, no, not
Orissa is a
Odisha,
West-
state of Assam. There are several boards.
But this is in a
What
different
is the
footing.
status
I don't
in
know. my lord.
respect of pay commission? Yes,
I don't know, my lord. Like
in
Assam,
respect of other boards.
like APDCL, they have their own income, source of income. So other boards, they do not function like Assam. I know Assam Government Marketing Corporation. So marketing corporation cannot be compared with this. Marketing corporation, they have their own, they are mainly, my lord, into the business of sales. Now I'll submit.
Giving approval, the fund is already there. Why?
Already there.
The approval?
Well, only one judgment I would like to point out. I'll just conclude, my lord.
We'll complete.
No, no, you complete. We are just asking.
Yes, ma'am.
That point of dispute is to be that you are not only one there.
My lord will, then I have to read my impugn order, my lord. Between the lines, there are few things, my lord, that I have to read.
The Odisha High Court judgment I am pointing, it is from the Khadi Board. Well, there the benefit was not given from the date which was given to the state government. So court discussed in details. Your lordship may not go through the all the cases, paragraph. It starts from page 6. Your lordship may kindly see the notes. I have annexed the notes in regard to the judgment. The state government employees provided benefit of, may I read the note, man? It should be easier.
Yes, yes.
My friend has made it meticulously. I have also gone. State government employees provided the benefit of 6 pay commission from 116, but the board employees were given the benefit from 1110. Area salary as per the rules 1998 and 2008 were not considered. Government employees provided the rules with effect from 96, but did not release the area salary with effect from 1996 to 2010, and also the DA from the from 17-2000. The board is like a government department. Expenditure met by the grants in aid. Your lordship, this is what it has been needed. 100% grants in aid towards the salaries of the employees. Similarly, paragraph 3, 4, and 5. In 1990-10, government says sanction of DA and revised pay do not apply to state government undertaking, etc., and asks the board to calculate the revised pay for the purpose of grants in it. In spite of this, the Odisha revised pay scales of 1998 not implemented. 6 pay commission benefit given with effect from 1/4/2010, the area salary and DA so and so were not considered. Now, if your lordship looks into pay, ultimately, my lord, there is a direction that you give the benefit as was given to the state. It has been held that it is for all purposes, it is state. Now, in the impugn order.
So here is a case where subsequent period benefit has been given.
No,
They're
no,
claiming
the
for area.
benefit was given from 2010 instead of 2006.
That's right.
So the court directed, no, you cannot treat them differently because they are like the government department for all purpose and looking into all the provisions of the act and the regulation. There is a regulation also, if your lordship kindly see that I have annexed. That regulation B, my lord, note is there.
So the first thing is, by operation of law, is the revision of pay applicable to a board?
Yes.
You have to adopt it.
Yes, board has a
Board has to adopt it.
Board has
It's not a
adopted.
case. It is not a case that by default, merely because the revision of pay was made, it will automatically be applicable to board employees.
Board has approved, cabinet has approved, board has approved, cabinet has, even the sanction of the fund has been given. But the sanction, my lord, they are not allowing to utilize it.
All right.
And my lord, as regard the, my lord, accounts part, the chief executive officer is up-to-date accounts has been audited. Chief executive officer has said. So taking into consideration the provisions of the board and the regulation also. Regulation for a second, my lord, I will take your lordship. In the note, my lord.
Yes.
Note I have given, my lord, as regard to what has been stated in the affidavit, as regard in the read petition and that regulation part, annexure A is there, second part. Annexure A, second. Rule 24 empowers the board to make budget estimates and annual program and to submit to the government by 28th September every year. The budget shall, along with other, include subsidies and grants pay of officers.
You're reading the regulation.
Regulation. As a lordship officer, in the
Annexure
note.
C. Annexure C.
No, annexure A, my lord.
Annexure A.
That note regarding the
All right.
act is there, my lord. Next page.
Next.
That important provisions of the Assam Khadi and Village Industries Board rules and regulation. The rules and regulation I have annexed it. Your lordship will get it in the after the act. It is there. CBA. The rule 20, your lordship. It will sum up my argument also. Empowers the board to make budget estimates and annual program and to submit to the government by 28th September. So the budget shall, along with others, include also. Rule 33 empowers board to create posts. The board has power with the approval of the state government, make regulation regarding gratuity, medical, contributory fund. In view of the provisions of the act and the rules stated above, the board is to prepare their own budget among others, incorporating the salaries of the employees, and government admittedly have been providing the budgetary allocation to the board from its inception, including the benefit of the ROP since 1964. Even though there were conditions that the board will meet the requirement of the benefit of the ROP from its own source. It was there, it was always there. For the year 2017-18, although the benefit of the ROP 2017 was sanctioned and released, as can be seen from page 2218, the inaction on the part of the government in not giving approval for utilization of the fund is unreasonable and arbitrary. The petitioner said that since inception of the board, the government have been allocating the funds for their salaries and benefit of the ROP through budgetary allocation, and therefore there is no reason for not providing the benefit of the ROP 2017 only on the ground that as per section 18 of the Act, the board shall have to provide the benefit of the ROP from their own source. This is what their stand is, totally ignoring the fact that even for the purpose of allowances and salaries, the government allocates funds as the board does not have any income of their own and only implements schemes the government provides from time to time. The petitioner submits their ROP 2017. The employees of the Khadi Board are not barred from getting the benefit of 2017 as they have been delisted from the purview of the public enterprise as far back in the year 2022. The petitioner says that the respondent authorities have totally ignored the fact that the salaries and allowances of the board are paid by the government through budgetary allocation from the inception of the board, including the ROP benefit 1964. And the similar benefits thereafter have also been provided by the government through budgetary allocation till 2010. Therefore, not providing of the benefit of 2017, even of the sanction and allocation of funds for the same in the year 2017-18 is explicitly arbitrary, and therefore they are liable for a suitable direction from it. So this is my whole prayer is, and the regulations I have shown, my lord, even the Odisha High Court judgment will show, my lord, this is for all purpose, this is the state government, my lord, it's a government department, and they cannot, my lord, distinguish with their, they can treat differently, but in the treatment which has been made to the other government. So therefore I pray, my lord, as the petitioner has been getting the benefit 2016 from the inception onwards, and the 2017 benefit not giving the benefit of 2017 is arbitrary, and therefore they are liable to it. My lord, all the accounts have been submitted, and because if your lordship goes into the impugn order, now they cannot go beyond the impugn order. Impugn order says, my lord, for the purpose of consideration of the benefit of the ROP 2017, they will have to clear the account. This is one. And at the same time, they say that they will have to generate their own. So this itself, my lord, I think it is not a good, the order has not been written with application of. Lord. Anything, my lord, I have given the note, entire note is there. which states, my lord, what the contention of the petitioner, contention of the additional chief secretary, contention of the finance department, and our affidavit, and the finance department affidavit is there, affidavit in reply, affidavit of the petitioners. In details, I have given, all prepared by my friend.
Thank you.
You want to?
So first, let us hear who's the parent department. Hear the parent department.
I will come first to the impleadment matter. Page number 53 of the written petition matter.
53.
Of the written petition.
Yes.
And I'm reading from the second paragraph. In the matter, my lord, this impleadment order is the fallout from the earlier direction of his honorable court, my lord. And honorable court has directed us to examine and pass an appropriate manner speaking order. So we have passed this order. Second paragraph. In the matter, it may be recalled that with regard to the revision of pay scale to the employees of the Assam Khadi Village Industries Board, a proposal was sent to the AKVIB to the Department of Handloom and Textile on 5 to 18. Since the matter relating to the revision of pay scale, making budget provision, granting aid for the same for within the jurisdiction of Finance Department. The proposal was sent to the Finance Department for approval. The Finance Department in the matter by its endorsement dated 28 to 18 has communicated the following. I'm reading my number one. The administrative department ensures that conditions laid down in the notification number 17/118 is followed. My lord, that
Where
already
is the notification?
my 16 years already, my lord.
Page 62.
Page 62, my lord.
For 2002, they have been delisted from the public sector.
My lord, again, I will read that, my lord. 62, my lord.
Yeah.
The board of directors, my lord, I am on page 62, my lord. I'm reading for one, my lord. The board of directors of each SLPES, that is, my lord, public, state level public enterprise, shall decide to adopt the provisions regarding revisions of pay, scale, allowance and payment of areas A as per Assam Service ROP 2017. After examining the detailed financial involvement regarding pay revision. Pay revision is to be allowed with the approval of the administrative department concerned. Only after the board of directors agree that the SLPE concerned has adequate financial resources. My lord, this to be marked. It is, my lord, the Khadi board has to, my lord, first has to examine whether they have money in their coffer, my lord. This is very important. Adequate financial resources to be made the expenditure for payment of the revised pay scale allowance for the area pay. The PSC having net profit for the last 3 consecutive years up to 2016-17 with positive net worth, and those who are in position to meet the additional financial burden for payment of salary on the revised pay because of the implementation of pay revisions of 2017 from their current operational profit may be allowed to adopt the rules of respective PS, my lord. So meaning thereby, my lord, they have to have their own money in their own coffer. Then only, my lord, they can go ahead. PSC are to ensure that their annual income are adopted up to 2016-17 in their respective AGMs before allowing pay revision. So, my lord, it is the burden of the Assam Khadi Village Industries Board that they should have their own money first, adequate money, then only they can go ahead. The administrative department shall examine at its own level the proposal received from the, that is, my lord, administrative department is asked, my lord, we'll examine, my lord, under its control to revision of pay, etc., along with the decisions of the board, ensure that the state level PE concerned has adequate financial resources. That is what, my lord, we have been asking that whether they have done their budget, my lord, audit. If unless they do their audit, my lord, we will never know whether they have money in their own coffer to meet the expenditure of pay revision. To meet the expenditure for paying the revision of pay, allowances for the arrear pay, and thereafter follow the revision of pay scale. No reference to finance department will be necessary. If they have their own money, my lord, they have adequate budget in them, my lord, then no reference to finance department will be necessary. If we are, my lord, satisfied that they have the money, satisfied, my lord, we call for that audit to show us that whether they have the money. Before allowing the pay revision by the administrative department, each of the SLPs would be required to sign a MOU with the administrative department indicating the exact number of posts and number of employees working against the sanctioned post. The said MOU should specifically provide that no fresh posts shall be created in the SLPs without prior approval of the finance department. This is to ensure that provision of AFRMB would not be violated if any, in any case.
Yeah.
So, my lord, now again I'm coming back to page number 53. As a whole, my lord, if we go by this clause 1 of the order, my lord, we said that they have to have their adequate, my lord, financial resources to back up their any pay revision, my lord. That is the thing, my lord. Number 2, the no post would be created. That is, my lord, already we have read. Number 3 is very important, my lord. Assam Khadi and Village Industries Board will bear the entire financial liabilities arising out of the revision of pay out of their own budget, and no financial assistance will be given by the state government for this purpose. My lord, we are very clear. We will not give any financial, my lord, aid. Regular pay, my lord, we are paying, but for pay revision, my lord, granting aid, we allow, my lord, for regular salary. But for pay revision, my lord, this is an extra thing on us. They have to earn, my lord. It's a board. They have their own board. It's a money-making, my lord, enterprise. They have to do business like Odisha. My lord, they have to earn profit. Then only, my lord, unless they have sitting there, my lord, we cannot give, my lord.
Where is the finding that their earnings are not up to mark?
That is, my lord, that is what we said. If they have their own money, they cannot access money. Khadi Board cannot tell us that you give us granting aid, you raise the granting aid for our pay revision. If they have money,
You are already paying granting aid.
granting aid full regular salary.
Why?
My lord, seems, my lord, they could not, my lord. Actually, my lord, we do not pay granting aid for salary though. We to just keep it afloat, my lord. They could not make certain expenditure.
Where are these findings here in this order?
My lord, I'm coming, my lord.
Well, may I just interpret for 1 second, madam? Lord. Well, page, like the officers, if my learned pen also reads it in the similar manner, it will be difficult to assist your lordship. Page 63, my lord, what my learned pen has read. 62. Application of mine is in many places it is not there. Your lordship will kindly see that first sentence in exercise of the power is pleased to order that the individual state level public enterprise. This is in regard to the state level public enterprise. Now page 30, your lordship will kindly see. This is what I have been saying, that there should be application of mine somewhere, my lord. Page 30. Otherwise, how they were given the benefit of the ROP 2010, 2000. Page 30, your lordship will kindly see.
Yes.
Yes. They, with reference to the letter on the subject stated above, I am directed to inform you that the Public Enterprise Department is viewed that since Assam Khadi Board, Industrial Board has predominantly a developmental and promotional role, the enterprise has been delisted from the public enterprise. So how this notification is applicable? Some finance officer has written something, well, this way, that way. And this notification I have shown, this is applicable only in respect of the state level public enterprise. Now they are saying
No,
that,
if you are not a public enterprise, then what are you?
no, I'm a board, my lord. I'm a board and it's a board and they have said it's a developmental and promotional role. This notification itself says, act says, regulation says. It is not a public sector they have delisted me, my lord. And accordingly, they have been given, probably because of this, they have delisted us because they are required to pay everything from the state budget.
They are not government servant.
They are treating, they are
not government servant, my lord.
for,
Assam Khadi, it's a board, my lord. They have shareholders, everything, my lord. They are not government.
There is no quarrel on that they are not government servant.
But my lord, you can note, because on this I will place few judgments of the Honorable Supreme Court. From here only, from our High Court, it went to Supreme Court, and what the Supreme Court laid down regarding salary and such thing of how it to be dealt.
the board also looked into the Assam disciplinary appeal rules. If they follow, I'm just, because in the Odisha High Court judgment, they have said that what board has done. So everything besides the act, they have reiterated the provisions of the act and also said, they follow the provisions of the disciplinary rules, government of Assam. And the CEOs are appointed by the government. Chairmen are appointed by the government. So these things are also there. And they have been paid. Here, the sanction has been provided by the finance.
Yes.
So, my lord, my understanding is that
There is a cabinet approval of some proposal. Cabinet is approved. That has not been revolved or modified, amended. When the highest level in the administration has approved it, why are the authorities below trying to frustrate it?
no, my lord, cabinet did not approve, my lord.
Huh? It is,
That is,
which page is the cabinet approval?
there is cabinet approval.
It is a page 39, I think.
33, I think.
33 is previous.
Previous.
6 pay commission.
That is the approval.
Minor committee.
Page 39. Page 39, last portion.
No, this is not a cabinet approval.
This is a minutes of the meeting held on
the meeting.
in the conference room of the Honorable
What is
Chief
that page?
Minister.
What is that page 33?
33 is that regarding 6th pay commission.
Yes, that is 6 pay commission.
6th pay commission, this is 7th pay commission.
So, my lord, for 7 pay commission, there is no cabinet approval, my lord. That is what we said, there is no cabinet approval. Unless there is no cabinet approval, my lord, how can we go further, my lord?
You place it before the cabinet.
My lord, either my senior to complete or
No, I'm not.
He is completed. We have asked him a question, he has replied.
my lord. No, my lord. If he wants to continue, my lord, I can sit, my lord. I take.
No, he is completed.
My lord.
The meeting has only resolved to direct the department to examine.
Examine. There is no cabinet approval, my lord.
Yes, all right. What's your judgment?
My lord, that pay revision part, my friend from the finance bill, my lord, in a similar such case, my lord, regarding pay and allowance. Corporation, my lord, went up, it came before the Honorable this High Court. The High Court passed an order in favor of them, my lord. Then the division bench even upheld, my lord. Then the state went to, my lord, the Honorable Apex Court, my lord. My lord, I will just read few lines. My lord, the last page, my lord, from para 11, my lord, I will just straight go to the findings. What was held, my lord, by the honorable apex court.
Yeah.
The last page, my lord. From para 11, my lord, I'm reading. What clearly holds the field at present in the principle laid down and reiterated by the constituent bench of this court in Steel Authority of India versus National Union Waterfront Workers in such and such. We wish to clear the air that the principle while discharging public functions and duties, the government companies, corporations, societies, which are instrumentally or agencies of the government must be subjected to the same limitations in the field of public law, constitutional or administrative law, as the government itself does not lead to the interference that they become agents of the center state government for the purpose so as to bind such government for all their acts, liabilities, obligations under various central and state acts or under private law. We therefore reject the interpretation put forth by the respondent on the tentative observation of Kapila Hingorani 1 and 2 to contend that the government would be liable to payment of salaries and other dues of the employees of the public sector undertaking. We are of the considered view that the decision of the High Court cannot therefore be sustained. We accordingly allow this appeal, set aside the order of the division bench, the learned single judge of the High Court, and dismiss the writ petition without prejudice to the right of the employees of Kamul to such action as is available in the law for redressal of their grievances. We may also add that this decision will not come in their way for the state government formulating any scheme or extending any relief or benefits to the Kamul employees for their similar situation to the person's ballot. My lord, here the Honorable Supreme Court is held that the government is not liable to pay the salaries and, my lord, such benefit to the companies, PSUs, societies, my lord.
No, that is not the ratio. The claim of the petitioners were that they were on deputation to the veterinary department and they had claimed their area salary. That was rejected because they were not employees of the government.
Exactly, my lord. They are also not the employees of government.
That's right. That's why we are asking you, why are you giving them budgetary provision for salary?
My lord, just to keep them floating, my lord.
Why?
My lord, it's a granting aid, my lord.
That's right.
Granting aid means, my lord, it's a like mercy. My lord, we want to keep it so that we are helping them.
Give them grants and aid at par with salaries near about par with salaries with other employees. Let us say hypothetically these state government employees are earning 100 rupees. You are giving them grants in aid for 20 rupees. And to say that we are trying to keep them floating. Why?
No.
You can't pay 100 rupees, pay at least 80 rupees.
My lord, will take into consideration that they are a profit-making enterprise.
That's right.
They
so
are not
we are
government
asking you,
employees, my lord. They are not
we are
public
asking
servants.
you, why are you
My lord,
giving
they are
grants
not
in aid?
public
You
servants,
take
my
a
lord.
call. You take a call and close it.
My
You have the liberty to take a call and wind up the board if you want.
My lord, the thing is that they are not public servants. They are not.
We know that. We know that they are not public servants. We are asking you
My lord,
that the direction was to examine the matter properly. You had given us, the order was that they'll have to earn their own living. All right. We agree that some amount of responsibility of the board is also necessary, but you are giving them grants in aid.
Grants in aid. My lord, we know.
For what purpose? For payment of salary. The grants in aid are being used not for anything else but for payment of salary.
Yes, my lord.
You give a proportionate revision of pay and give them grants in aid accordingly.
My lord, to some extent we can help, my lord, but to some extent we are helping, my lord. But
and this
when
order
they come in,
and this order does not reflect that what is the financial status of the board.
My lord.
What is the financial status?
Financial, that is what, my lord, we have asked them to go for it.
You are the parent
No, my lord.
department.
No.
Are you not the parent department?
My lord, we give grant in aid. It is the board who runs the thing, my lord. Entire show and it
Mr.
is.
Counsel, you are giving public money. Are you telling me that you have no authority over the board to call for their accounts?
That is why, my lord, that is the accountant general, my lord has raised the flag.
What accountant general?
That is why, my lord, we said, first you complete your audit.
If they have not complete, you take steps. You have considered their application on the ground that these accounts are not available, they have not completed.
And
You
second thing-
examine their
second
account
thing, my lord,
and
we
give
have
a
made it
reason
very
finding.
clear that we have made it very clear
Hmm.
that you have to earn your own
I agree, but you are paying them grants in aid for their salaries. What for?
seller, my lord.
For what purpose? If they have to earn their profit and look after them, which is very good. Hypothetically, theoretically, in principle, you are correct. They are governed by an act. They have a set of regulations. Other than appointment of the board, constitution of the board, they're they are a self-funding authority, but you're giving them grants in aid.
My lord.
Now, if you are giving them grants in aid, you have to examine whether these grants in aid are sufficient for what purpose. For payment of salary, it is by your own admission. By your own admission, it is not for grants in aid for any other thing.
My lord, we
You have to take a call that no, we are not providing any grants in aid because accounts are not available. Yes, we are providing grants in aid only for the salary which is available, whatever keep is there. These grants in aid, we are not giving additional benefit for this, whatever reason. But fact is, you are saying that it is an independent board, it is a profit-making body. Where are your accounts to say that? These accounts are not placed. There is nothing in the order to say that as a parent department, you have passed appropriate orders calling for the necessary account to find out what is the financial health of the board. They've got so many outlets. What is the income out of that? How this money has been utilized?
that is what Balin page 54 in our impugned order, my lord.
Your impugned order is very vague. That's what we are trying to tell you.
No, my lord.
Your impugned order is giving reference to finance department, giving reference to that notification that these are the conditions, they have not been able to do it, so we reject. This is not how it is to be done.
Exactly, my lord. During that point of time, we did not have they did not, my lord, for 12 years, they did not do any audit.
Your order reflects that the accounts of the board should be examined by so and so, reply of so and so on request. Where is the finding that in spite of the accounts being called for, they had not been furnished before you? It has to be, some responsibility has to be taken by the parent department.
In our impugned order, we have made it very clear. If they are
Clear, we are trying to read it, not clear.
My lord, we have very categorically, my lord, very clear that after audit.
We understand that. See, you have made it clear that your additional funds will be necessary for enhancement. What is not clear is what is the grant in aid you are paying and what is the salary you are paying. All these will be reflected in the account. What is the income generated from the outlet? Where is this money being utilized? If they are not doing it, it is for you to call and examine the matter. You should have examined this matter because there is already an order that you will consider their representation. Considering representation means consider it. If it is capable of being accepted,
my lord,
accept it. If it is not capable, reject it. Give reason.
My lord, that point of time, there was no audit. We could not have gone forward with the consideration. That is why we said, my lord. And my lord, I'll be, my lord, very candid, my lord. This order was passed, my lord. Subsequent, my lord, there was a contempt proceeding was pending, my lord. They did not in one part, the Khadi was not coming up with any clear picture.
Your order
My lord,
reflects to endorsements made by the finance department.
my lord. Ultimately, my peer revision will go to finance, my lord. They are the one who take the call, my lord.
So before that, you have to take a call. Why have you passed this order if it is finance? You may simply say that it is the finance department who has to take a call. Why did you pass this order?
My lord, as a parent department, my lord, these are the directions. Because we are also answerable to the finance department.
Let
We
us
have to
say,
seek money.
let us say tomorrow the chairman, vice chairman, secretary, whoever have a topic, who will make the appointment to fill up the post? Finance department. It has to be
They have,
parent
they have,
department.
no, my lord. Khadi will take, my lord.
With approval. Whose approval?
The approval of, my lord,
Whose approval?
of the department, my lord.
Which department?
Finance, my lord. No, my lord, past the thing is that they have to take sanction from the finance, my lord, because money will come ultimately from the finance.
Anyway,
That is what, my lord,
we record
it
your
is there.
submission that handloom
No post
sericulture has
OP.
no role to play.
No,
You are essentially saying is that there is no role to play.
No, we have a role to play.
What is your role? That's what we are asking you. What role do you have?
My lord, during that point of time, our role was to tell them that go for an audit because you did not do audit for the last 12 years. And this is the, my lord, findings of the finance department. That is what we have to tell them. That is what, my lord.
So essentially, what you are saying is the role of the department is to act like a post office. When board's information, you send it to finance, finance information, you send it to the board.
My lord will understand one thing, my lord, that they did not have the, my lord, requisite audit reports of 12 years. It takes, my lord, it takes 1 year time to complete it, my lord.
In the order, you did not mention that. You did not mention that in spite of directions issued by the department, these audits were never there. In the absence of these audit reports, no order can be passed. You did not say that.
My lord, we have stated, as per the report of the Accountant General Assam, the account of Assam Khadi Village Industries Board was not duly audited by the competent authority since 12 years.
That is in 2019, you are passing the order in 22. Accountant General's observation is 2019.
My lord.
Your order is in 2022.
My lord will take into consideration one thing, from 2020 March to, my lord, 22, my lord, there was a COVID, my lord. We could hardly, my lord, people could, my lord will take that into consideration. My lord.
COVID has long gone now.
Long gone, but that period is there, my lord, still standing between us.
All these reading between the lines would have been avoided if your order was had more clarity as to what is the role of the department and why the prayer has been rejected. Department has to consciously take a decision here. Yes, any other judgments you want to please?
My friend is will take another.
Yes. You are representing which respondent?
My lord, I'm for respondent number 1.
What?
No, my lord, respondent number 3 and 4, 3 and 4, my lord. 3 and 4, my lord, 3 and 4.
Yes. Yes.
The finances read as party respondent number 2 here. So we have filed our affidavit. Let us see, my lord, what is the claim of the petitioner at page 21.
Yes.
Page 21. Read in the nature of certiorari, my lord, they are challenging that impugned order, my lord. Annexure 12, which appears at page 23, my lord, page 53, which lordship has put pointed queries right now. And my lord, second prayer is a writ in the nature of mandamus directing the respondent authorities to implement the revised pay scale as per revision of pay rules 2017 to the employees of Assam Khadi Village Industries Board forthwith, creating the nature of mandamus directing the respondent authorities to pay salaries and allowances due to the members of the petitioner association and all other employees of Khadi Industries Board, including areas as per pay scale fixed on ROP 2017. So they are basically claiming the benefits of pay revision, my lord, arising out of revision of pay, my lord, by dint of ROP 2017. Prior to that, my lord, prior to that, in terms of my lord cabinet approval, they were getting the benefits of ROP, although they are not government employees. Nonetheless, they were getting the benefit of ROP at par with the pay scales of ROP. And the expenditures were, my lord, borne, my lord, at that point of time, my lord, by the board, as well as, my lord, by the, in terms of grants in aid. That lordship will find, my lord, at page.
Mr. Goswami, I think you can come back in the second half instead of keeping you waiting. We thought this matter would be taken up without much time. Sorry to keep you waiting. We'll take up your matter in second half. Yes.
Now, till my lord,
Professional hazard.
Professional.
From both sides.
For the bench, for the bar, not for the bench. Yes.
now, prior to 2017, they were getting the benefits of ROP. Now, post 2017, my lord, when 2017 ROP rules came to be implemented with effect from 1/4/2016, there, my lord, the bottleneck started. And there, my lord, the dispute started. And to that extent, if lordship may be pleased to, my lord, come to the affidavit filed by the finance department that starts, because I will be, my lord, submitting only on the financial aspects and further on the issue whether they are at all entitled to a writ of mandamus. Because they are urging for a writ of mandamus, it will be a positive direction. If lordship is to take up page 117, my lord, paragraph 4. I will have to slowly read, my lord, because from yes, factual matrix, my lord, is involved.
Yes.
I'm so obliged. That as regards to the statements made in paragraph 2 of the writ petition, the deponent begs to state that the Assam Khadi and Village Industrial Board, herein after referred to as, is a creation of statute and regulated by Assam Khadi and Village Industries Boards Act. The board receives granting aid from the state government from where the salaries of its employees are paid. As per section 18(1) of the act, the board shall have its own fund and all receipts of the board shall be credited thereto and all payments by the board shall be made therefrom. Lordship will kindly mark this, my lord. All payments made by the board shall be made therefrom. So payment means payment of salary. There is not a single document on record, even to remotely suggest that, my lord, at any point of time, the salaries, my lord, salaries of, my lord, the employees of this Khadi board, even for the matter of, my lord, extending the benefits of ROP 2010, wherever, my lord, given by the state government. The state government gives granting aid. At the end of the day, it is the board who will make the payment. So it is an act and the act is clear, the provisions are clear. There is not a single document. Of course, if my learned counterpart brings any
document
with regard to the fact that at any point of time, the state government had directly made payment of salaries to the.
See, let us make one thing very clear. There is no confusion that they are not government employees.
Government employees, but they are claiming the benefits that are given to the government employees. So therefore, I am making that submission because submissions were forthcoming from this side, my lord, that the chairman is getting a car, he is getting that much of salary, my lord. They are trying to draw an analogy. I have to refute it, my lord, that much. The lordship may kindly be pleased, my lord, to directly come to the annexures, my lord. Page 133. My lord, it is an extract of, my lord, the Assam Khadi and Village Industries Board Amendment Act 1970. The original act is, my lord, of Assam Khadi and Village Industries Board Act 1955. The lordship will find at page 133 itself. Now, if lordship may be pleased to come to page 134. My lord, what does section 18 say? My lord, at page 134, lordship will find section 18. On the left-hand side, lordship will kindly see funds of board on the left-hand column. There are two columns.
130,
134.
34.
134. 134. Lordship will find section 18. Just on the left-hand side, lordship will find a column, my lord. That is, my lord, the synopsis of that, my lord, section 18. Section 18 deals with funds of board. Now, what does section 18 says? 18.1.
So see, this is what we wanted to know from the parent department. If you think the finance wants to do it, you can do it. You have to, there is no denial that you are giving grant in it.
Yes.
For payment of salary.
Not for payment of salary, for meeting
No,
all
that
other.
never meant it.
No,
That payment
never
of
meant
salary.
it. No, salary is one of the components.
Maybe.
Salary is one of the components.
Notwithstanding that they have their own, they are required under the act, they are required to have their own.
But then again,
Now
my lord,
they have given a proposal for giving them the revised pay or whatever. Maybe the revised pay as given to the government servant, or maybe somewhere closer to the revision. So there has to be a proper inquiry in the matter to find out what is the salary they have got, what is the income they have got,
absolutely. Absolutely.
how much is the proposal,
Absolutely.
what is the financial burden.
Absolutely. Lordship has
So
got it.
who
Yes.
who is supposed to do that?
Yes. Now, I am to, my lord, make submissions on behalf of the finance department for how, my lord, we are dealing with the matter. What is our role, my lord? Thereby resisting the claim in the repetition. Section 18 says, my lord, the board shall have its own fund and all receipts of the board shall be credited thereto and all payments by the board shall be made therefrom. Then 2 says, subsection 2, the board may accept grants, subventions, donations, and gifts and receive loans from government or Khadi and Village Industries Commission. Lordship will kindly mark it. So grant in aid is only one component of external finance, external financial aid. Apart from, my lord, the board having.
What are you trying to say?
No, because, my lord, at the end of the day, my lord, only because of the fact that the government has.
We are not on that. We are on this fact that there is no dispute that the board is required to earn it, have its own revenue. No dispute. The act says. There is also no dispute that the government has deep and pervasive control in the affairs of the board, chairman, secretary, board members, etc., all appointed. Your perhaps audit or everything is quite. Notwithstanding that, or keeping in view with these provisions, you have also given a grants in aid.
Yes, grants in aid.
Are we to understand the grants in aid are given just like that without examining their position? No.
Yes, my lord, therefore.
So there must be some effort by the department on some proposals or otherwise that yes, this much of funding is necessary for the board to complete these things.
Which is evidently lacking here. Which is evidently lacking.
No, that's what I'm saying. It is evidently lacking.
Yes.
Then as the department who has been directed to look into their grievances by an order of the
Yes.
court.
So therefore, what is the stand of the finance department? That is my
stand of the finance department is universal. Then you want to reject.
No, it's not reject, my lord. We not reject. We have stated that board will have to take the responsibility and board will have to, my lord, uplift its, my lord, money making capacity.
That is not for you to decide. You can only say whether in terms of the act they are entitled or not entitled.
Times of
Whether
the
they want, how
they are
much
not
of it they
entitled.
want to earn or not, it's not for finance department to decide.
No, therefore,
Bound by the act.
yes, so therefore my
So
first
if the
submission is
approval
that they are not, no,
If the approval is to be taken, it has to be understood that the administrative department, under which this board has been formed, is the authority to give the approval. You
administrative.
may raise issues that this proposal is not permissible under that notification or this route or that. That's quite all right.
Correct. But my lord, here, my lord, several factual parameters are involved. First leg of my submission will be, my lord, they are not entitled to the relief sought for because of the plain and simple reason there is a bar created under section 18. Number one, let me be precise then. Then lordship will kindly come to my lord, page 136.
No, that the all right, you can argue on this, but we are on the ground that the order which is being challenged here is the order at page number 53 or 52.
53. No, apart from challenging the order, the second relief is they are claiming a writ of mandamus.
That's all right. We'll examine that.
Yes. So therefore, I will have to resist it. At the end of the day, my lord, the money will flow, my lord. So I will have to resist it. It is financial matter. So therefore, lordship will kindly be pleased to come to page 136. My lord, this is the Assam Service Revision of Pay Rules 2017. On the strength of which, my lord, they are claiming a writ of mandamus. That give us the same benefit because you have granted the revision of pay rule benefit at an earlier point of time. Whether granting ROP at an earlier point of time will, my lord, create a promissory estoppel in against the government that no, now also you will have to do. To that extent, I will be making my submission. Kindly. Now,
yes,
my lord, application of the rules, lordship will find, my lord, please 136.
no, we are only on the issue of the correctness of the order. Mandamus to issue or not to issue, we'll decide later. Presently, we are examining the correctness of the order.
Then, my lord, I will be reserving my argument, my lord, because apart from that, my lord, our decision is
Mr.
also-
Das, your grievance is essentially in respect of the order.
Yes, but this is without application of mine, and money has been already, the amount has already been given to the board. They are not being allowed to be utilized by the department. And your lordship will kindly see, my lord, the benefit of the ROP,
The amount which has been sent to you
yes,
is sufficient to include the
yes,
higher pay.
yes.
The amount
They
has
have been
sent.
giving it, and now they are, because they are unable to utilize. The board is there, my lord,
it is
board's
to be-
advocate is there.
If the amount is
And-
not to be utilized, that's what we are asking you, that the amount grants in aid which is provided will be on the basis of a proposal which is sent. And this proposal, with or without modification, will be accepted that this grants in aid is for X, Y, Z.
Yes. So therefore, my lord, if 100 rupees is, my lord, sent, for example, as a granting rate, whether that 100 rupees will be sufficient, my lord, then of course, my lord, my colleague will be able.
No. Sufficiency is later.
Yes.
It is to be utilized for what purpose?
The utilization for, my lord, salaries and other purposes also.
That's right. So it is on the basis of the proposal which is raised and accepted by the finance department.
No, finance has never accepted it. Kindly see, therefore, my lord, kindly see 138, page 138, kindly see. Therefore, I will have to make things clear, my lord. Kindly see, page 138,
No. What we are asking you
my lord.
is the grants in aid which is being given. Are you saying that this grants in aid is being provided without finance approval?
No, finance is there, finance approval is there, but so far as, therefore, my lord, till the sixth pay commission, they were getting everything.
You are getting into these details. We are not asking you there. We are asking you
Yes,
the grants in aid
yes,
which they have sought for
yes.
through the parent department has been approved by the finance department, and therefore some amount has gone.
Some amount has gone.
Now, this amount to be utilized for what purpose will be reflected in your record in the orders which are allowing the grants in aid or in the proposal.
Yes, that will be reflected
Now,
in
the
the
submission
administrative
of the
department's records.
submission of the Senate Council is this grants in aid which has been allotted would be sufficient to take care of the enhancement in the salary. Otherwise, it is being paid for salary.
Yes,
but it will, the amount which you have sanctioned, it's not an additional amount. The amount which has been sanctioned is sufficient to take care of their enhancement.
Yes, my lord. To
Now-
that extent, my reply will be, my lord, that is only a submission. There is no material on record to suggest that. Let him, my lord, show any material, my lord. That, my lord, on
Let him, why should we ask for that matter if this is a submission on the basis of instruction? We'll direct them that if it covers, they should be allowed.
no, it doesn't cover.
Then-
Question of covering doesn't arise. Because the accounts have not been audited. Accounts have not been audited till
But-
2022.
We are asking you a question, your reply is diffused. It has to be a pointed reply.
My lord,
Runs in it, paid or not paid, allowed or not allowed.
not allowed.
Your lordship may record that.
Kindly see, my lord. Therefore, kindly see, my lord. Kindly see, my lord.
All right, we'll come back again.
Yes, 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 definitely. I will demonstrate from the documents itself. So something is pleaded in the repetition, something is argued before the court, my lord. Therefore, my lord, I am
There, both. When if the item was not called into surpass,
Yes,
Huh?
we missed the notice.
notice, no, it is not in the telegraph also, my lord. Now
No,
it's
it is there in the daily list, there's a notice
oh,
already
yeah, we
published.
missed it. We were
there
sitting
in the website.
next edition.
Yeah, we have 15, 15.
My lord.
This month. How will it? Hola.
up to kindly, my lord, page 135 of my affidavit. Finance affidavit, running page 135.
Yes.
One page.
135. Communication from the administrative department, my lord, to the Khadi Board. There, my lord, there of 5 scale of pay to the employees of Assam Khadi Board and Industry Board as per Assam Card ROP 1998. Now, my document contains inviting a refined letter of I am directed to say that the governor of Assam allow the benefit of Assam Card ROP 1998 the officer staff of India provisionally on the following conditions. Document kindly come to serial number down below.
Yes.
The ACERD shall bear, that is the board, shall bear the entire financial liability arising out of the division of pay out of their own budget provision, including the equal provision for aid payable by the state government, and no more payment of any additional fund to ACERD shall be entered by government under any circumstances. So, my lord, meaning thereby, whatever grant they had, my lord, whatever money they had, they generated from their own fund, as per section 18, which constitutes the payroll, my lord, as well as, my lord, taking into account the grants in aid, both have to be clubbed together and form that fund, my lord, that purpose, if it can be, my lord, the benefit of ROP 19, it can be granted, then it may be granted. So, this was the condition of that government. What happened thereafter, my lord? Now, when 2017 rules came to be published, so they kindly come to page 138. And we see my lord going for the 11 and exercise 138.
Yes.
This is the official endorsement, my lord, by the Finance Research Unit Department, the Helping Sector, which is the Administrative Department. And then CRE Department have no objection to the Cabinet Memorandum for division of pay scale to the employees of Assam Khadi Village Industry Board as proposed by the department, subject to the condition that the Administrative Department ensures that conditions laid down in notification no force should be fully created. Then number 3 is important. Assam Khadi and Village Industry Board will bear the entire financial liability arising out of the renovation of pay out of their own budget, and out of their own budget, and no financial assistance is given by the state government for this purpose. So the mind of the government was very clear, madam. So far as finance department is concerned, that you have to pay it from your own, fund, own budget. Then no, it will kindly come, to page 141. That is of utmost importance, madam. Because in pursuance of this, official notice, the appeal order came to this, I may read it, page 141. Again, an endorsement by the Finance Department to the Handloom Textile Department, I will quickly read it, Finance Treasury Department has earlier offered no objection towards proposal for taking concurrent towards decision of pay scale to the employees of HIE as per ROP 2017 with condition that these three conditions considered already in matter. However, Handloom Textile and Sericulture Department stated that the Assam Khadi Board and Trade Industries Board is granting aid from government and the granted aid received would not be sufficient to meet the additional financial implication that would arise out of on account of revision of pay. As such, the matter was taken up by the Finance Audit Department and it was observed that as per Accountant General Assam report, the account of Assam Khadi and Trade Industries Board was not duly audited by the competent authority since 12 years, with effect from 2006-2007 onward. This was the pointed query which Lordship made, Madam. As such, the present financial condition of Assam Khadi and Village Industries Board is not known, and how the board will be able to pay revised pay scale as per ROP 2017 for their officers and staff from their own source. Accordingly, Handloom Textile and Agriculture Department was advised to get the accounts of Khadi Industries Village Board examined by the competent authority on an urgent basis, and after that, the authority may decide for granting the revised pay scale. It has been further learned that up-to-date audit has not been conducted as yet by the competent authority. In absence of the up-to-date audit report, it will not be possible to gauge the financial condition of Assam Khadi and Village Industries Board as to whether the board will be able to pay the revised pay scale of Assam Khadi Division of Trade 2017 to their officers and staff from their own source. Until and unless the financial condition of the board is strong, only then the board will be able to meet the additional expenditure arising out of trade revision. Secretary, Handloom Textile Department note so and so stated that the Accountant General Assam Khadi's audit report has so and so, whereas it's only a claim for fee. It is not related to salary. As such, Handloom and Textile Department is requested to furnish the up-to-date status of audit report and pursue the progress of the contempt case. Now, this is where my lord, the matter got solved. It was exactly the pointed query made by your lordship just prior to the case. So that
In view of the contempt proceedings, this order was passed. Perhaps.
appears to be so. Appears to be so. Appears to be so. So, how my lord,
So
the matter stands.
let this matter be examined again. By the authorities, you get whatever audited reports are there and all, you pass it. That is what is to be done.
Let him come, I will take some time.
Okay.
Correct facts are not placed before the court.
Okay. All right, then. That's all.
And one, and my lord, I will rely my
Yes.
Up to paragraph 12, my lord. What was the yeah,
Fair.
paragraph 12? I have marked it, my lord. Paragraph 12. My lord, that's page
Yes.
10. The short question which calls for consideration before this court is whether the original institutional dedicated employees working with the respondent board are entitled to the benefits flowing from subsequent resolutions stated so and so. Another question is posed for consideration before the court is whether the principle of negative equality can be applicable in a case where other employees were wrongly granted the benefits or the employees who are claiming the priority shall have to establish their rights independently at the particular benefit. Now, here also, at an earlier point of time, and it's not wrongly, madam, but it was a conscious decision of the government that the benefits of ROP 1998 onwards were given to them on account of their financial health. So, if we finally come to my paragraph 13.3, 13.4, madam, for that matter. 13.3, madam, thank you, sorry, 13.3. When being the designated employee working in the respondent board, they cannot claim parity with the employees of the state government. The respondent board is an autonomous and statutory body created under an act. Here also it is ultimate for the respondent board to take a conscious decision, which can be termed as a policy on the pay scale to be adopted and or certain benefits have financial implications. Everything depends upon its economic viability or the financial capacity of the employer. As per settled position of law, the economic viability or the financial capacity of the employer is an important factor while fixing the wage structure. Otherwise, the individual may not be able to function and they have to be closed down inevitably and have disastrous consequences for the employees themselves. As per the settled position of law, the employees cannot legitimately claim their pay scale. They claim that their pay scale should necessarily be defined or they must be granted certain external benefits. Then 13.4. As per the settled position of law, equation of post and salary is a complex matter. It left to the expert body and undertaking, and court cannot interfere likely granting of pay quality by the court may result in a cascading effect, having adverse consequences. There are limitations or qualifications to the applicability of the doctrine of equal pay for equal work. And let me finally come to paragraph 14. At the cost of litigation, I will not mark it, madam, I apologize. Paragraph 14. At the cost of litigation, it is observed that unless and until the board has specifically adopted the government resolutions of 1991 and 2, like adopting the parent resolution that is going to, the daily rated employees of the respondent board shall not be entitled to any benefit flowing from the resolution of 12. Therefore, 12 has madam heard. Then paragraph 12, 15.1. As held by this court in the case of Rajkumar Prabha Supra, in a case of appointment or case test, Article 14 of the Constitution does not represent negative equality. As if the state has committed a mistake, it cannot be forced to perpetuate the same mistake. Then paragraph 16, madam, this is the penalty when paragraph B I will be relying. Applying the law laid down by the court in the aforementioned the facts of the case on the hand, and as observed herein above, the daily rated employees of the board cannot claim as a matter of right the benefits flowing from the government resolution that is going so. And as such, they are not entitled to the benefits flowing from the resolution that is going so automatically. And considering the fact that even subsequently the mistake committed by other donor officials have been corrected and benefits mistakenly or inadvertently have been done, and even recovery thought the direct signatures committed error in holding that the action of the respondent board is not guaranteeing benefits flowing from the discriminatory in violation of Article 14. The same has been corrected. So therefore, my lord, I am placing on record to resist their claim of taking a writ of mandamus so as to give them the benefit of ROP 2007. But they cannot claim as a matter of right that, of course, my lord, if it is adopted, strictly adopted, taking into consideration all the financial parameters, my lord, definitely tomorrow, my lord, the board, the financial condition, because as on today, my lord, the financial condition of the Khadi and Jewelry Industries Board is not known to any one of us. Now, tomorrow, my lord, the audit has to be completed and done by the accountant general. Only when, my lord, the audited reports are placed before the authorities concerned, then only a consideration will be able to be taken. If it is found, that yes, the financial parameters are such that the ROP rule 2017 can be extended, definitely it will be extended, my lord. So it will depend on so many parameters, so many conditions and combinations are involved here. It's not that typically, my lord, at one point of time, a benefit was given to a particular group of employees, that subsequently also they carry that same right, my lord. And that right, if I extinguish, no, not so. Because I cannot tell beyond the materials on record. And finance department has only made this observation that no final decision as such, my lord, has been given by the finance department as such, because the audited reports are not made. This is how the matter stands. And at that 11 point of time, so this is absolutely correct, my lord. Having gone through, my lord, page 141 of my affidavit, a contempt case was taken before the General Court, and then that sitting order was passed. Now, if my lord holds, my lord, that in order, because possibly examining the decision-making process in Article 226, so therefore, he proceeds to the conclusion, my lord, that this sitting order was not passed, my lord, in accordance with law. So definitely, lord, can demand the matter. But so far as the difference of mandamus per se, at this stage, my lord, in my aspect of submission, my lord, it will be discussed. And so
Khadi Board.
that financial status of the board is not there to that. Deductible I take the 150,
150.
150.
Yes.
That's a letter from the CEO of the board to the clarified that serial number 4. Serial number 4. The balance sheet already 2.8 is one completed. In the year 2023, I did that the board had forwarded the balance sheet for the financial year 2021.
Where is it?
Serial number 4.
4.
Serial number 5 is the total funds available from the account. FD etc. Account 31 to 39 to odd. That the total requirement of funds is paid device as per our 70 comes at 29 crore for the period.
So what is the amount required for? What is the amount required for the enhanced pay?
Yes, if it is paid revised pilot, then it will be 29 crore for the lakh.
And the amount available is 39 lakh.
39.
This is in the bank account or FD?
There is no bank account plan.
What is the meaning of that?
All together.
You have to identify, you have to indicate what is that FD for, what is that security for,
That
whether that amount can be used for payment of enhanced salary.
now that something has been paid, that financial status is not possible.
No, all right. But you say that your amount is 39 crores, whereas the requirement is 29 crores. You'll be left with a balance of 10 crores. Now, this is for the salary for the current period. Now with 10 crores, how do you intend to pay the salary for the next year?
Position for the period 2023. March 2023. They are aware of
Yes.
now they have to make a call to whether they can take on.
Where is the board resolution? Is there a board resolution? Payment of enhanced salary.
These are given proposals for now everything in opposition. 241.
Wait.
241.
41.
From there the proposal starts. The proposal. Of the board.
Yes.
We got a proposal. Forty-one, 242. Okay, I'm not going to all this, but these are the proposals given for the division of pay for the employee.
Yes.
If board meeting also are for later prefer. Resolution was taken for
In 30 minutes.
Division at page 39.
But this is subsequent to the order passed. The impugned order was passed on 22, and this is 2023. The order which is challenged in the writ petition, whereby they say that the financial accounts, etc., were not available, therefore proposal rejected, was passed on 24th of January 2022, page number 53. And the communication which the board has said,
It is March
23. So it calls for re-examination in view of this.
Only that they are paying, and the amount required for the division of pay is also there in the budget. But sanction is not. Because of the sanction order, that is not there. Money is there, funds are there.
For what purpose the fund was there?
They are also
For what purpose the fund was there?
that I do not be able to say properly. From this letter, page 1.
The fund which you have reflected in your 23 communication is 39 crore. Was any proposal said, was any fund received on account of the enhanced salary?
No.
Then
There was some purpose, but
how the surpluses come is what we are asking. There has to be a proper accountability. I mean,
so those have been
written
sent.
accounts have to be
All the
reflected.
details have been sent to the parent department.
You bring it
Not
before the court, see
let him,
what let him make. You, where is your communication again?
150.
150. If we at 150, please come to serial number 4. This is the balance sheet, so and so under 2021, 22 part B is under process. Total fund available as on 31/3/2022. This total fund is it the earnings of the board alone?
Along with the
What is the where is the segregation? What is the amount earned by the board? What is the amount given by the?
record, but that has been already sent.
No, that may have been sent, but we wanted to know from you because you are the board. You produce it so that there is a proper understanding as to how much of grants in aid have been received by the board and for what purpose. Mr. Dutch?
One aspect I just wanted to show this, my lord. I think the court is not being assisted properly. my lord. First, your lordship will can be figured at page 58 here. 58. And page 58, your lordship will can be see. I'll just
Yes.
take your lordship quickly in the note it is there. Page 58, as your lordship got it, no?
Delisting.
Yes, clarification on the finance department's endorsement. Lordship got it?
Delisting.
No, this is not delisting. Delisting at page 30.
Hmm.
This is dated 10/2/2022.
Yes.
Now, my lord, next page, page 59. all the information has been provided. Now below, my lord, last. The board could not place proposal for sanction of the last, my lord, may I read? For allocated fund owing to non-grant of revised pay scale as per ROP 2017 to the AKB. If the proposal for grant of revised pay scale is accepted, then the required fund for the 21-22 can be met from the current year's 21-22 budget allocated amount. Already amount allocated. Now it may be mentioned here that since inception, the employees of the board have been enjoying the benefits of salary. Then where is the difficulty? Why is that this arbitrariness? We have been paying this since inception of the board. Salaries, dearness allowances and revised pay scales, etc. at par with the state government employees whatsoever extended by the government till date. The government extended the benefit of the revised pay scales to the board employees as per ROP 2010 through cabinet decision, and the fund required for the proposed were sanctioned and released by the government through state government budget grants in aid.
Is it pursuant to some orders?
No. This is the this is the letter given for the purpose of all the communications which have received. Now another factor.
Although strictly the doctrine of provisory estoppel may not be applicable here, but you see, the government will take decisions.
No. In view
Mainly because they were doing it for the last 10 years, 20 years, 30 years. Where is the bar that they cannot change it unless?
No, my lord. Why I am saying is that, my lord, if your lordship goes through that Odisha High Court judgment, Odisha High Court judgment, it says that is also a board. And what they are saying, that is also board. Board, it says it is like a government department. They have been differentiated, my lord, with the government employee. So therefore, court directed, you cannot differentiate, and you will have to give the benefit as has been given to the government.
What is your argument?
That is one of the that since they have been given since from the inception, and like the government employees.
All right, you may argue, but this ground that you are employees of the board, and since you have been given salary at par with the government, and therefore government has to continue to do it.
The government has not applied their mind. Your lordship will kindly say, at one hand they are saying that you have not given the.
We are only trying to appreciate your argument.
Yes.
Is it your argument that you are claiming this revision of pay on the ground that since inception government has been paying it at par with the government?
Not only that,
at par with the
they
government.
have already paid. They have not sanctioned it. Your lordship will kindly bear with me for 5 minutes. Well, my lord, page 58, your lordship has seen, my lord. Then page 63, your lordship will kindly see. Because I think the court has not been put forward with proper facts. Now, one hand, they are saying that you have not given the audit reports. All audit reports are given, my lord. It is audited by the Auditor General. Page 63, your lordship will kindly see. I am forwarded here with the draft separate audit reports on accounts of the Khadi Board for the year 2006-7 to 2013-14. This your lordship will kindly see. Then page 64, your lordship will kindly. This is up to 17-18. Then page 65, 17-18. Then all this government allocation of fund has been shown. Page 66. 66 onwards, my lord. This is government allocation, government of Assam's my lord, grant. It is not only for the. It is for the Sericulture Department, Handloom Department, Industries Department, page 73. Page 73, all these departments grants in aids are there. So 2018-19 is there.
This is only for salary.
Yes, salaries and other grants, my lord, including my lord, this
salary, other components.
Yes, other components. Now I'll come, my lord. 2018 page 2018. You'll tell me. The lordship is not being placed with correct facts. Number one, I am saying, my lord, all audit accounts have been placed before by the authority, and it has been duly audited by the auditor. Now, page 218, your lordship will kindly see, page 218. 218. It's here only. Wait. 218. This is a letter from the Chief Executive Officer. They are all ACS officers, my lord, run by the, placed by the government. My lord, your lordship has seen, my lord, page 218.
Yeah.
My lord, this is pursuant to that government letter dated 2018, that SLP, that state level, state public sector undertaking. Now, last paragraph, your lordship will can say. First paragraph I will read, my lord, regarding the conditions laid down in the notification dated 17/1/2018. Your lordship has seen the public sector undertaking that was meant for. It may be mentioned that the Assam Khadi Board does not fall under the purview of the SLP, as the board has already been delisted from the public enterprise system by government letter dated 2002. That is page 30. I have your lordship. Then, as far as the preparation for separate MOU with the state government is concerned, a note is enclosed herewith. It may be mentioned that as per the Khadi Board Act 1955, all debts and expenditures, all contracts into all the matters and things engaged to be done are vested with the state government. Now, last part, paragraph 7, paragraph 3. AKB board receives all financial liabilities from the state government as committed expenditure under established through the state government budget provision as grants in it under the head so and so, so and so. The next sentence, my lord, the board receives funds under the revenue and capital head. As you also got it. Then from the state budget, the board will be able to bear the liabilities arising out of revised pay scale as per ROP 2017. Now, the government has already sanctioned and released fund to the board as per revised pay scale as ROP 2017 against board's budget proposal. Hence, all financial liabilities are borne from the state budget as grants in it. So they have already done it, my lord, but they are not giving the sanction for what purpose? Budget, the money has already come to the board. Now, your lordship will kindly see page 219. And the government officer doesn't act, I understand, my lord, but they must not act in a manner in which, my lord, the court will be not given the correct fact. My lord, again, it is a letter, my lord, from so and so to the chief executive officer, with reference to the subject cited above. I am directly to inform you that the matter regarding grants of pays and so on to the employees of the board is under sub judice. So therefore, we are not going to decide the matter. What are you saying before the court? You are saying the accounts is not complete. That is wrong. Up-to-date accounts have been given. I have given all the details of the accounts. Second, you are saying that, my lord, will not decide because the matter is pending before the court. Then has to be genuine, my lord, and the money has been already given. Budget was prepared, budgeted money has been already given, but you are not allowed to utilize it. So therefore, my submission before the court is, my lord, if your lordship go through they cannot, my lord, arbitrarily, my lord, discriminate the board from utilizing the fund already sanctioned for the 7 pay commission. And if your lordship, I take recourse to the Orissa High Court decision, which says, my lord, the board is like a government department and you cannot discriminate with them to that of the employees of the other department. So I pray, my lord, your lordship will direct them. Since all the materials regarding the account statement, all have been there, and the chief executive officer, this is not the board's officer, this is the officer appointed by the government. He has already said that the amount has already been sanctioned. It should be utilized. They are just arbitrarily, my lord, withholding, as if, my lord, the board's employees are somebody foreign from this land. They are not being treated properly. All these employees, only 202 employees are there. They will retire. I think the government has already taken a decision to close down Assam, this Khadi Board. So therefore, depriving them will cause injustice to all the petitioners, my lord, who have been enjoying the benefit of the ROP since inception. So therefore, my prayer, humble prayer before Lordship is that your Lordship will direct them, since all the materials are before the board. They should, and they should allow to use the fund already allocated through the budget. Now the question is, it is not that they have not allotted the fund, they have already allotted the fund. Budget has been considered. That means the finances are already approved. Only thing is that, my lord, they are not allowing to use the fund. And now they are saying, my lord, at last whenever they wanted the accounts, they say no, now we will not take any decision because the matter is pending in the. Most of the employees are in the verge of, my lord, retirement. They are giving the benefit only to the regular employee. Earlier it was 600, now it is 202. And, my lord, Odisha High Court judgment, my lord, paragraph 28. When regulation provided the power to the state government to manage the employee, questions of payment and other allowances from other income of the board does not arise.
There are 28.
My lord, the judgments, yes, para 28, 33, and 34. 33, my lord, they have discussed Bihar Khadi Board also. I am giving a copy of the Odisha Khadi Board Act similar to our board.
Alright.
They have, my lord, in my humble sense, they have acted in a very lackluster manner, both in court and in office.
All right.
I'm deeply sorry. My lord, I'm sorry that item number 21, we
We
were,
are in the middle of a hearing.
my lord, that absence has been shown, but I was present.
We are in the middle of a hearing, Mr. Saike.
Yes, ma'am.
You are interrupting a hearing.
No, my name, presence may be shown, my lord, in item number 21, which was hearing. Hey, one and. Oh, sorry. I thought that hearing was over.
Yes. Hmm?
There are two projects. One is Khadi Board for the Sangha. There is no appointment, in the disposition. That P1 is a registered association. It is an unregistered association. And P2 is to be, the secretary. Kindly, come to page 23. I apologize for touching in on this page.
Yes.
Page 5, that paragraph 1 of the repetition it is stated, that the petitioner number 1 is an associational employee of 30th Village Industry Board and is a registered trade union of the office of the register of trade union. So no details.
P2 is the secretary.
Yes,
of the of petitioner one
for petitioner one.
is an employee of the board.
That we do not know.
Huh?
That we do not.
Petitioner two is an employee.
Yes. But
All right.
no credential, no credential is annexed to the petition. Either there is appointment to the effect that he too is an employee. He too. There is no appointment in the petition that he too is an employee of Khadi Board. And he one, my lord, appears to be a unregistered associate. No certificate of registration or whatsoever, my lord, has been annexed to the petition. It is a fundamental defense, my lord. And in the affidavit at page 23, my lord, the second paragraph, it is, my lord, it is sworn by my lord P2, Donald Bolwa, that paragraph 1 of the affidavit at page 23 is stated, I am the petitioner number 2 in the instance and duly authorized by the members of association. No authorization is annexed to the repetition. On that sound alone, my lord, repetition is liable to be. I am not going even to the repetition is effective. There is a straight decision on the account file. Meghalaya one year association. It is my
Tell us the cited.
yes, it is 2010 2 CLT 670.
2000,
2010.
2000 volume 10.
Yes, 2010, madam. 2010 volume 2. 2010 volume 2 CLT 673.
Party name.
Party name, my lord, Meghalaya Wine Dealers Association. State of Meghalaya. Meghalaya Wine Dealers Association, State of Meghalaya. And my lord, the equivalent citation, there is another equivalent citation, my lord, that is 2010 5 CLR. 2010 5 CLR 330. It is a division bank certificate, my lord. It says, my lord, that restitution at the instance of unregistered association is not maintained. And secondly, my lord, there is no material on record, my lord, and to remotely suggest, my lord, that there was a cabinet approval, my lord, so far as extending the benefit of ROP 2017. And number two, my lord, that the additional amount has been earmarked because there will have to be additional amount on account of their revision, my lord. There is an increase in the base. So we adopt, my lord, 2017 ROP. The additional amount is, my lord, not clear. It's not full. It is not available on record. That is the additional amount. Even from the affidavit filed, my lord.
It is there in their affidavit.
Yes. No, that is there in the affidavit, but that is not a part of the decision-making process. That may be a part of the affidavit. That may be a part of the affidavit, but that is not a part of the decision-making.
No, that then you are assailing the decision of your the parent department. You are questioning the decision of the parent department.
No, now there is a
By
link.
whom? There is a communication by the board.
Yes,
This is the breakup. Now, if it is not relied upon by the parent department, it is their shortcoming.
After passing of the impute order.
Right.
So therefore, the related thing, my lord, to the parent department to take a place for my.
We'll see what orders we can pass.
Regarding,
That's all.
regarding my learned friends, my lord, submission, is an association of employees of the Khadi Board. Lordship will kindly see his affidavit. In response to the paragraph 1 of the writ petition, he says, made in paragraph 1 of the writ petition, deponent has no comment to. No comment to.
He may not have, his clients may not have any comment.
He himself may.
They can argue.
I understand that.
Question of law,
Secretary,
Law.
is number
Points of law.
petitioner number 2.
We
Where
can't
the question of
restrict,
law will depend
we
upon
can't
facts
restrict
only.
councils from raising points of law. Should we? All right.
So, my lord, the court, whatever weapons and materials are available, I can only plead, my lord.
Yeah.
Deep level.
We are not reserving it. We'll pass orders on 20 May 20. released on 20 May. For years, admission other orders.
Well, I have given notes on everything.
Yes.
And so, like,
Okay, sir, what key problem? Itu mistake. Huh? Yes, Mr. Soikia.
Sorry, sir. I missed it. I think about 20, not 21. It's actually there. So I have to show you the step. My request that I will show the step.
You are present in the court, but not before this court.
Respondent was also shown a step. What
Keep it. All right.
Complex.
Yes, sir. Yes.
That case got it. This case was approved by the government. That is the cabinet. So it's serving the neighbor. But that may be a different case. That may be technical. And in that case, it allows.
Item 22.
Here, the next one.
Yes. Item 22. Hmm. Do you have anything to submit, Mr. Goswami Yadav? You are not appearing in 22.
No.
Item 22, Mr. H. Talukdar for the petitioner, Mr. Nayak. Mr. Nayak submits that. What has been served? Additional evidence.
No, the petitioner, copy of the
Submits that. The writ petitioner in item 22 is shown to have been approved by the what has been approved by the cabinet?
But although his case was approved by the cabinet
For what?
For regularization.
So
That is the claim.
Submits that the claim of the petitioner is that his claim for regularization was approved by the cabinet, but effective orders have not been issued. Mr. Nayak submits that he would like to complete his instruction in this regard and file necessary affidavit. In the matter. Is accordingly. After 3 weeks, 4 weeks, this item 22 is segregated and be listed separately as item from 23. Yes.
Last day also I was pointing it out. All these appointments were subsequent to 31/3/1996. It also comes to the prayer. Prayer or faith will.
Yes.
Faith will. Not it was prayer. A declaration. there is that the petitioner has been included in a record that will in the fact of the case that the so it might have been considered of I will submit as a point. Second point a piece of member must be directing the respondent to tolerate the petitioner and pay them the offender without penalty. And basically, so they are paying for a mandamata, directing the respondent to regularize. On this point, Dr. basically does
So your case is that long years of service by itself will not call for regularization.
it doesn't create any right.
It doesn't create any right in view of
Unless there is a
Umadevi,
unless there is a scheme initiated by the government
already by the,
on to fulfill the condition practice. That is my
no. Fulfilling the cases of Umar Devi is in respect of the scheme or to be included in a scheme. There are conditions which, if they fulfill, government may formulate a scheme.
So government should
Formulate
initiate a
one-time measure.
for those who fulfill the character of the market.
Right.
For others, not there is no such direction. There other
And your case is that department's case is that notwithstanding the years of service which they have rendered, their initial appointment into the cadre was not as per the rules. As per the scheme, earlier scheme. That their cases are not included in those schemes. Why?
they were first thing not satisfied for the date of appearance. Up to 2005, we considered regularization of those officers who were engaged prior to 31st May 1990.
And they are appointed in
Subsequent to March. So they never come under the head of the scheme by the government.
and then yes. Okay, then
And what we have is clear and whether mandamus can be issued.
it may be mandamus, it may be certiorari, it may be any other order or director in the nature of a mandamus. So let us not go into this. Your saying is that mandamus requires an enforceable legal right which they don't have.
Yes. On that point,
All right, you may submit your judgment. We want to know that in the face of the judgments of the recent judgments by the apex in similar matters, where people who have rendered long years of service without regularization, their cases are considered by the you first start with Prem Singh, let us Prem.
Starting from paragraph 3.
Yes. Yes.
Paragraph 3.
Para 3. Yes.
The facts are being narrated from is if I did an affiliate was appointed as a vendor in the in a box system of study. He was transferred from one system. Thereafter, admitted to the selection of the recommended price. His services were price of and was posted as farm operated in the regular. His superintendent was then he filed a writ petition in the High Court to count periods spent in the box as qualified. The High Court directed submit accordingly it was filed with an objection yet another representation filed with the same date by order of executive the petitioner stated
Yes.
whether the portion of market prior to the regulation can be calculated of qualified parties or investment. So that was the issue. So document clearly here to press the brief thing in factor is notice it was a regular article. If notice comes to paragraph 20,
Para 30.
yes.
Yes.
And it only has paragraph 20. So already court was discussed calculating the earlier code. Last line. However, the services of the evidence in few it have not been regulated. It is to say for several decades. So probably other than the brain thing or it's not for evidence with services. So up to till paragraph 30 law, there is no mention of any put has not been regulated. It's start up only 3 lines. Then ultimate paragraph is the page 6, paragraph 30. Paragraph 30. Here are some of the employees have not been regularized in spite of having handed out here the 30 days. Here the honorable court has not support employees. Here are some of the employees who have been regularized in spite of having rendered the services for 24 to 40, whereas they have been surrendered as they have worked in the work system and not in a here services or have been regularized. So my first submission is that one government structure was, and in spite of having that structure, their services were not paid. That's one. Second, and even as per the decision of this court, state of Karnataka, the two grounds noted. First, one government instruction was there, and second, Umadevi's conditions were also made. Probably they would have those. This court in the state has laid down that in case
in case services have been rendered for more than 10 years without the cover of the court order as one-time measure, the services be regularized of such employees. In the fact of the case, those employees have worked 10 years should have been regularized. It would not be proper to regulate them for consideration of regularization as others have been regulated. We direct that their services be regulated. So after reading this paragraph, I would like to go to paragraph of modification. Here, Lordship has said two conditions have been mentioned. This paragraph.
Kindly read it again. The part.
Here are some of the employees who have not been regularized.
Para 36.
Yes. Here are some of the employees who have not been regularized in spite of having rendered the services for 50 or more years, whereas they have been separated as they have worked in the work that subscription not their services ought to have been regularized under the government structure and even as per the code in the state of Karnataka. This code in the state system has laid down that in case services have been rendered for more than 10 years without the cover of the court and the interim paper, as one-time measure, the services be regularized of in the fact of the case, those employees who have worked for 10 years or more should have been regularized. It would not be proper to regulate them for consideration of regularization as others have been regularized. We direct that their services be regular. Now, lottery is not close to this paragraph. Two conditions are there. One, government instruction was there. Umadevi's conditions were there. And the conditions mentioned by this honorable court, I mean the Supreme Court, are two. That is 10 years without the cover of the court order. The first 10 years, second one is without any protection of the court order. Now, notice after this paragraph, notice of the paragraph.
Thousand.
One aspect needs to be clarified. There may be cases where irregular appointment or political appointment has explained and RN and PN and record to the therapeutic of duly qualified second, right? And the employees have work for 10 years. More but without the intervention of order of the court or outside. The question of regularization of such employee may have to be considered on merit in the light of the principle right in the cases of two and in the light of the reason. In this context, the Union of India, the state government, and their influences should take steps or to regularize as once I mentioned. The services of such irregularly appointed have worked for 10 years or more in duly sanctioned but not under the cover of order of the court or the tribunal and should further ensure that regular recruitment are undertaken till those vacant sanctions that require to be filled up. In cases where temporary employees or basic wages are being now held, the process must be set in motion in 6 months from this date. We also clarify that regularization, if any, already made, but not subject, need not be reopened based on assessment. But there should be no further bifurcation of the constitutional requirement and regularizing or making permanent those not duly appointed as per the Constitution. The lordship has seen here three conditions. One is 10 years or more. Second is without any intervention of the court. And third one is to take the court. But in the preempting judgment, only conditions are the paragraph 53 lordship 2.9 lordship. First one is three conditions. One has to fulfill, only then this is for regularization can be considered as one. And second is that the last three lines of those whose services has already been regularized, their cases will not be reopened. But and then for lordship, after passing of this judgment, there should be no bypassing of the condition that has been written in paragraph 50 of the Uma division. Last three lines of it, once again I would like to read. But there should be no further bypassing of the constitutional requirement and regularizing or making permanent both not duly appointed. So that is the hurdle lordship would face after the time. It is not that we are not trying to regularize both gender, but on this point, lordship, I would like to first clear that the state government, even after 2009, tried to find out a way for regularization of the death out employees.
Before that, I just want to understand the meaning of this sentence. Para 36 of Prem Singh, which you have referred.
In my understanding, not
that it would not be proper to regulate that particular sentence.
Yes.
Or you can read from one or two sentences above, just to maintain the continuity.
As they have worked in the work side, no. What has not been, I would like to refer to that
No, no,
long period of
before you refer, first, I want to understand the import of this sentence. What is the meaning of this sentence?
that is the third one, not or the
In-
first.
In the facts of the case, para 36.
Yes. There are some of the employees who have not been regularized by the vetting center. The services for the or whereas they have been corrected as they have worked in the work system and not in their services ought to have been regularized under the government. So My understanding, Lordship, one government instruction was there, and as per that instruction, their services should have been regularized.
Prem Singh judgment.
Yes.
Para 36.
Yes.
You read para 36. There are some employees.
Here are some of the employees who have not been regularized in spite of having rendered the services for 4 years, whereas they have been separated. Already they have been there. Yes, they have worked in the worker establishment, not against any particular project. Their services ought to have been regularized under the government instruction. So government instruction was there. That instruction also covers the case of those employees. But in spite of that, those government instructions, their services were not regularized. And even as per the decision of the court in state of Karnataka versus Mali, this court in the state decision has laid down that in case services have been rendered for more than 10 years without the cover of the court order, they are not the short as one-time measure prepared fulfillment of preconditions. The services be regularized as such. In the facts of the case, those employees who have worked for 10 years or should have been regularized. It would not be proper to regulate them for consideration of regularization. As others have been regularized, we direct them their services be treated as a regular one. So according to the court order, these employees fulfill two conditions, that is 10 years plus without any of the court. Third, persons similar to them lordship has been regularized, but their service has not been. That is why I am reading lordship.
So therefore, what is the direction of?
However, so that is the direction. We direct that their services be treated as a regular one. So it's like something like deemed one.
So, now, Mr. Goswami, the court has regularized their services. It is.
Yes, Peter.
There is no direction to the department to regularize.
No, no.
Court considers
Court
their
said that it is deemed to have been regularized. Because that's a category which was not regularized in that case. And court said that even though they are not regularized, that is the last paragraph which you are lordship referred.
And it leads to a bigger area.
Area.
No, for you to art.
That's what I am doing.
No, 142 versus 226.
No, it is
that
not
the
142. Your lordship, kindly see, this is not 142.
Is that the 140 has to be?
No, it is not that. Because there are subsequent decisions which say that because it said that the entire period of service will be taken into account.
Okay, we are in this judgment now. This judgment has actually considered them to be regular.
True, my lord. Kindly consider this, my lord. A man is appointed as a temporary government servant.
We agree with everything.
Yes.
There are questions which can be asked to the department that why did you allow people to work for endless number of years, regular scale of pay, when you could have very well gone for regular appointment, number one. If their work charge for master road workers, that their appointment is with regard to a particular project or project. Once it comes to an end, they should have been discharged. But they are carrying on. So these are questions which government may be required to answer. Why this endless? The whole problem was created because of this. That they now say that we have got a accrued right. You allowed us to work. But there is no dispute that the initial entry was not by as per the rule. There was no
There were no rules. That's the whole problem.
No. The otherwise service rules are there.
No. With regard to this, your lordship is finding in some of the states there are rules. In Assam, So far as work charge is concerned, there is no rule of
Right.
recruitment or of promotion
What
or
we are saying,
regularization.
these work charge and master role
Yes,
work in sanctioned or vacant posts which are otherwise required to be manned by grade 4 employee regularly appointed as per the rule.
Milord, with great respect, Milord, we tried to find out if there is a rule which we couldn't get.
No, no. We are not saying that master rule and work charge are to be governed by rules. We are not saying that there are no rules. We know.
No rule.
What we are saying is that for grade 4 there are a set of rules. For
Correct, correct. Your lordship
recruitment.
is right.
So on a given set of facts, the state could have
Could have.
adopted this set of rules
Could
to
have.
say we are selecting you as per the
No this.
nothing was done.
Huh.
You were selected, you were appointed, you were given salary, you were made to work.
Your service book was open. You were given increment. You
But
were
all said and
given
done,
this scale,
all said and
everything.
done, your selection was not in terms of an advertisement or there was no
We have
selection
said,
process.
Milord, and that is not denied. We were recruited in the same process which was prevalent at that time of recruitment.
For all regular employees.
Yes, that's what we said, not disputed.
Anyway, but this order of the apex court in judgment of the apex direction of the apex court in frame C
Yes.
appears to be under 140.
With respect, Milord,
Whether we can under 226 exercise similar power.
no, I am not on 142 at all, because your lordship, that's a different thing for Supreme Court.
Only reason why I'm asking
Yes,
reading the judgment
yes,
makes me feel or
Yes.
makes me understand,
Yes.
or at least I think I've understood, is that the dispute was somebody who worked for long years, subsequently regularized, but the earlier period was not counted for towards pension.
Yeah.
That our court, I think, we get past in Kubira
your lordship is right, Rajbangshi.
many years back.
Yes.
That you count this.
Yeah.
There is no quarrel on that. While doing so, the court also noticed that there are another set of employees who were never regularized. The number of years of service, everything was there, but they were never regularized. Therefore, the court, perhaps in this paragraph, has held or has directed their team to be regularized.
Absolutely.
Now, whether
That's the point.
now whether
That's the novelty and that's the advancement from the earlier situation.
even if this court is inclined to pass an order,
Your lordship.
questioning
Yes.
whether under 226 can do that.
Milord, 226 in a way is wider than Article 32
There is no quarrel on
and
that.
Article 142.
That will require some.
Yes. Why I am saying that, if your lordships recall that judgment of
Chaturvedi.
Justice Subarao.
E.C. Chaturvedi.
No,
Prior
that
to
is AR 66 Supreme Court, page 81. Can you get this? AR 66 Supreme Court, page 81.
Yes.
I think paragraph 3 and 4. It was put so simply that our hands are long enough, I am quoting from my memory, Milord, our hands are long enough to reach injustice anywhere within our territory.
So that's for the epic court to test.
No. Regarding power under 226 of the writ, that's the, it says that we don't go by that English technicality. As far as India is concerned, if your lordships have got the judgment, paragraph 3 and 4, your lordships will find. 66.
63.
Yes. And you get over the
66 Supreme Court 81.
Yes.
Dwarkana.
Dwarkana. para 3 and 4. In my very humble understanding, my lord,
But then
in
post-
my humble submission and my humble understanding, my lord, no case in Supreme Court has put it so simply, but with such pregnancy, my lord. And it has been quoted in many other cases subsequently without acknowledging this particular sentence, that our hands are long enough to reach injustice anywhere within our trade.
we would like to believe,
Your lordship should believe it,
but
because it
but
is said.
for subsequent judgments after PC Chaturthi. Your existing counsel might like to.
This remains a law even today. And subsequent cases have said this in their own words to the same effect. Kindly see this position, Miller. What are the facts? After all, Miller, it's a government service. Government needs people, therefore they are making a recruitment. The way they are making recruitment, we were no exception. We were appointed, our service book was open, we were given the scale, we are given the increments, and although the level is work charge, which normally would mean that you are attached to a particular project, with the completion thereof, you go. That is not in our case. Therefore, although you are giving me a level of work charge, in effect, I am not work charge as understood in PWC. We continue, and what does that imply? That you have the need for these people to work for decades before they reach the age of superannuation, and you superannuate them by a letter. Your appointment is by a letter saying that it's a temporary appointment. Then the service books are open, increments are given, scales is given. Now, Milord, it can be a mythical thing that he is not regular employee. This is what Prem Singh faced in para 36. And it says that there is a group who has not been regularized, but they should have been regularized, because they are at par with those who have been regularized. Therefore, the ultimate Miller test is the substance. Are these people working for the government for all these years? Yes. Are they confined only to one project? No. They'll work like any other employee of that category, from work to work as entrusted to them. And for that, the indications are not of a temporary casual employee. You don't open a service book for a casual employee in government service. You don't give them a scale. You don't give them an increment. Everything that a regular person gets, these people were given. It is no fault of theirs that the government didn't pass the order of regularization while they did for others. Therefore, would it not be unjust and unfair to a group of people who are similarly situated, but the government overlooked to regularize them? That's the crux of the matter, beloved. If they are not, why not? And that is the category, second category Prem Singh was dealing with. And subsequent to this, there are two judgments. I'll place them. Prem Singh said that the entire period will be taken as qualifying service. A judgment of two judges, this is three judges, said that this has gone a little too far. After regularization, whatever period was given, they will get. Subsequent to that, another two bench said that Prem Singh didn't mean that. This is a three-bench judgment, and the two-bench judgment of explaining that judgment is not correct.
Yes.
Because you can take the qualifying service as full. But nobody doubted that if in substance it is not a work charged worker, because he keeps going to different works as allotted, and it is not just one solitary year, from year to year till he reaches his superannuation, and he gets his service record opened, he gets the increment, he gets the scale, and he continues. What would that imply, Mr.? It is not work charge as per their nomenclature. It is a virtual permanence, but for the fact that you have overlooked to regularize them or you didn't want to regularize them, or you did not simply regularize them, would that deprive them of the service or the rights which accrue to them for all the years of service they have done? What is the rule, Milord? We have annexed those two notifications. And you have a look at that again. Crux is, they say, the years of service. And our rule says 20 years. I fulfill that. Did I not get the pension? That's the whole question. If not, why not? My learned friend on first day said that they are not even government employees. You have a letter from the government saying that you are appointed as a temporary employee. That doesn't require or deserve a reply against their own orders. And it doesn't stop there, Lord. They continue in a way as to how the regular employees are treated. Namely, what do? They open their service book, they are given a scale, they are given an increment, and then continue if they serve well till the date of superannuation. And that is what it has happened. And except for pension, everything else is like a regular person. Why should the pension be not granted? There has to be a rational basis for excluding this kind of a people, Miller. In all these cases, we have, at least I have not seen this narration of facts to support that the level of work charge is a misnomer, which the present facts will not reveal. You can't call them work charge if they are continued in your service for different work, and you give a scale, you give the other benefit, like a regular person. And that is what Prem Singh exactly did, Miller. Para 36, your lordships referred, that's the crux. And that is what our problem is in this case. even in para 34, kindly see me, Lord. Because there they had a set of rules which is absent so far Assam is concerned. But a rule which was read down by them, para 38 at page 541, as it would be unjust because 33 talks about this monthly salary and all that, my lord. If I may just put this. The question 33, the question arises whether the imposition of the rider that such service should be counted has to be rendered in between two spells of temporary and
Your reference to the facts of this case is para 36.
yes, absolutely, absolutely.
Para 33. The
Correct.
first part doesn't apply to you
Doesn't
guys
apply
yet.
because they were regularized.
They were regular.
Yes, but they have read down rule 3.8. And they have given a reason why they have read down in 34 itself. It would be unjust, illegal, and impermissible to make aforesaid classification to make Rule 3.8 valid and non-discriminatory. We have to read down the provisions of Rule 3.8 and hold that the services rendered even prior to regularization in the capacity of work charge employees, contingency, paid fund employees or non-pensionable establishments shall also be counted towards the qualifying service, even if such service is not preceded by temporary or regular appointment in a pensionable establishment. It has gone beyond that, Milord. Ours is a temporary appointment. The letter of appointments are annexed. In view of then, Milord 36, there are some of the employees who have not been regularized in spite of having rendered service for 30 to 40 years or more years, whereas they have been superannuated. As they have worked in the work charge establishment, not against any particular project, their services ought to have been regularized under the government instructions and even as per the decision of this state, Umadev. This court in the said decision has laid down that in the services have been rendered for more than 10 years without the cover of court's order as one-time measure, the services be regularized of such employees. In the facts of the case, those employees who have worked for 10 years or more should have been regularized. It's the government's obligation to have regularized. In our case, the default should not injure the person's rights to their exclusion. It would not be proper to regulate them for consideration of regularization as others have been regularized. We direct that their services be treated as a regular one. That's the direction, Miller. Because you faulted or defaulted in regularizing them, having continued their service with all the indexes which only indicate a person's, a regular person's service below. They say that their services be treated as a regular one. There is no other option. How would anyone construe these facts? A temporary order, a scale, increments, continuation in service uninterrupted in different assignments, transferring from place to place, and finally issuing a letter of superannuation. All these are indications, Miller, for whom? For a regular employee. You have treated, that's why our first prayer is we are treated to have been a regular employee. Otherwise, you could not have done all this in government service. And if you only on pension now take a turn and say, no, you won't get pension. Where have we regularized you? That is something you can't say. It will not be ethical for a government to say that to a retiring person after taking his service for decades. However, it is made clear they shall not be entitled to claiming any dues of difference in wages had they been continued in service regularly before attaining the age of superannuation. They shall be entitled to receive the pension as if they have retired from the regular establishment, and the services rendered by them right from the day they entered the workshops establishment shall be counted as qualifying service for the purpose of pension. This idea that the entire service will be considered led to two more judgments of two judge benches, as I have seen. I will complete this trilogy, so that will be better. Hmm? Okay. And then comes the Uday Pratap, which was cited by my learned friend on the last occasion. Okay.
He wants to, you can complete it here. We'll examine you. We'll give you that Uday Pratap. What was the judgment you were referring?
Yes, my learned friend cited that case.
2023 XP online.
Okay.
526. And there were a couple of judgments.
Uday Pratap Thakur.
Yes.
What is the citation in SCC? SCC, it's an SCR citation.
Online.
2023 SCC online SC 527. You copy it. That's it.
527.
527. William. More to put goal. Photo Uday Pratap Thakur, which was cited by my learned friend Miller on the last occasion.
It is also for counting of
that because same
services.
thing said the entire period will be counted, and they the question was whether they it is correct and in view of their rules which they have, and then it was para 19, my lord, the question is put at page 5, internal page 5.
Yeah.
The short question, whether the entire service rendered as work charge under the work charge establishment shall have to be counted and or considered for determination of the amount of pension after the work charge employees are regularized in the rules of 2013. Then they go ahead, my lord.
So it was restricted to only the aspect of counting the period of service rendered.
Correct. It was only relatable to that because Prem Singh said that entire service period will be available to be counted. Here they said that that is not possibly intended or whatever it is because this is a two-judge bench, that is three-judge bench. So they took the view that it is only only after the period of regularization, because in that case there was a set of rules, and under that rule they were regularized, and that is your lordship will get in paragraph 24. So, in view of the rules available, they say that this observation of Prem Singh is misplaced. Para 30, 23, the expression used is misplaced. Because insofar as the reliance placed upon the decision of the court in Prem Singh by the learned counsel appearing on behalf of the appellant is concerned, the reliance placed upon the said decision is absolutely misplaced. And paragraph 24, they say that it is observed and held that service rendered as work charge after their service have been regularized under regulation scheme, namely Rule 2013, and the circular shall be counted for the purpose of qualifying service for pension only as per Rule 5 of the rules of 2013.
Yeah.
And paragraph 23, last 4 lines, this court has not observed and held that the entire service rendered as work charge shall be considered counted for the quantum of pension. The decision of this court in the Prem Singh case, therefore, would be restricted. That is what they did. Would be restricted to counting of service rendered as work charge for qualifying service. So that in the next case, another division bench has said that their view is not correct. And that I will place, put.
2025 online 385.
2025. What is the name of that?
Either we can add
2025.
FCC online XC 385.
The paragraph 12 at the internal page 30, at the top, paragraph 12.
You have a copy?
Yeah.
Which is for which proposition?
That is, whether the entire period will be taken into account or not. That paragraph 12, they refer to Prem Singh, and then they refer to Uday Pratap. And then, my lord, if your lordships kindly turn to paragraph 13. In our respectful opinion, the above interpretation by the two judge bench of this court regarding the three judge bench decision in Premsing does not appear to be correct, as the three judge bench has been quite unambiguous in asserting that the entire period of service of the work charge employees has to be counted for pension. So they departed from that judge.
The, what is that, Uday Shankar?
Uday.
Uday Shankar, Uday Pratap did not question the aspect of counting the period work earlier. There was no quarrel in Uday Pratap.
True. They said that it should be restricted. Premsing should be restricted to only the period after regularization.
So it has effectively reiterated the same thing.
This is
without making
saying that don't restrict it. There you have gone wrong. That's what they are pointing out.
No, it says it has been quite unambiguous.
In our respectful opinion, the above interpretation by the two judgments of this court, namely the Uday Pratap Thakur's case, restricting Premsing to that period of 3 years subsequent to the regularization, that they are saying is not correct because of the reason they are giving in para 13. In our respectful opinion, the above interpretation by the two judge bench of this court regarding the three judge bench decision in Premsing does not appear to be correct, as three judge bench has been quite unambiguous in asserting that the entire period of service of the work charge employees has to be counted for the pension. Because Premsing said the entire period. Uday Pratap said that only from the date of regularization, and restrict Premsing to that. This part of the case, I am only drawing your lordship's attention because Uday Pratap was cited that a subsequent Supreme Court division bench judgment has taken the view that Uday Pratap was not correct. Only for that purpose, because that question is not appearing in our case. Whether you take the entire period or less than entire period, for the simple reason, in our case, the pension rules and the notifications which we have annexed, which your lordship will get at page of our writ petition. Oh, sorry. Page 55 of the writ petition and page 57, these are the two notifications so far Assam is concerned. Because others have some kind of rules which were interpreted. We don't have those rules. First is at page 55, 12 September 1996. Pensionary benefit to the state government pensioners, family pension holders. In the government of Assam circular issued under office memorandum dated 10/8/63, a temporary government employee, our letter of appointment, as your lordship will recall, was a temporary government service, who retires after rendering temporary service of not less than 20 years. Under government, without being confirmed in any post, is to be allowed the pensionary benefits as available to a retiring confirmed government employee either on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by the appropriate medical authority. Said OM came into force with effect from 1st September 1982. So it says that only no question of any a temporary government servant who is not confirmed, he will get if he has worked for 20 years. The governor of Assam is now pleased to clarify that all temporary government employees who have retired from the service under Governor of Assam, fulfilling the criteria of not less than 20 years of continuous service, will be eligible for pension from 1982 onward. This is, however, subject to the condition that they satisfy all conditions other than condition of permanency against permanent post under the government of Assam for usual pensioner benefit under the Assam Service Rules 1969. This benefit not admissible to any retirees who retire from service with retirement benefits under CPF. And we have said that we don't have that CPF at page 30. So it says below, in unmistakable terms, who are entitled to government pension as a temporary employee. So if you have served for 20 years, that is good enough. That is the qualifying period so far Assam is concerned. Then at page 57.
Yes.
This is a 6/9/2003.
Clarification.
Yes. In continuation of this notification dated 12/9/96, which is at page 55, it is reiterated that the said AM clearly lays down that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits. The focus is on 20 years of continuous service. After ending 20 years of service, if the government servant is superannuated or incapacitated or dead, is not the root point. Any confusion in this regard is against the spirit of OM referred to above. It is therefore clarified that the pensionary benefit as contemplated in the OM shall be admissible to a government servant who died after rendering 20 years of continuous service. Other terms and conditions for eligibility of pension shall remain same as ever, same as the usual. So the root or the moot point to be considered is the length of service you have done without conformity, without permanence. So with these two notifications, my lord, your lordship will now apply to the facts of the case. Because I may be wrong, subject to correction, but so far as the all other cases are concerned, your lordships have not got these facts as these people are projecting in the writ petition.
Yes.
Except the level of workshops, rest is below, we have said. And permanency is not there, moot point. It says that if you have served for 20 years, you are entitled to pay in substance.
Yes.
And with respect, Miller, that is the at the end of the service career, after taking all the service, Miller, for all these years, without blame, and in different types of work, with a great skill pay. Hmm? Lady. So these two notifications are absolutely clear. That is government's own policy. Another 25 judgment below 31-125 Sripal. It is reported or what? It is online. It is also available online. My friend has uploaded it. They say that don't use Uma Devi on all occasions. That is at bottom of page 16 below. See? Now, the citation I am told is 2025 in SC 144. I don't know how where to get this, but this is
Which judgment? Sripal.
Sripal and another versus Nagar Nigam Ghaziabad
25 SC
2025
INSC.
in SC 144. Para 14 at page 16 of that judgment mirror, last sentence. More importantly,
Yes. Para 14.
para 14,
Yes.
because reliance was placed on Uma Devi to contend that daily wage or temporary employees cannot claim permanent absorption in the absence of statutory rules providing for such absorption. However, as frequently reiterated, Uma Devi itself distinguishes between appointments that are illegal and those that are irregular, the latter being eligible for regularization if they meet certain conditions. More importantly, Uma Devi cannot serve as a shield to justify exploitative engagement persisting for years without the employer undertaking legitimate recruitment. It is not our fault that they have taken our service. And we have said that in the process or recruitment as per the policy then available and by which regular appointments were made. So it is not a shield. It is jago to kiba kamata hidden jago let refer to. It is one paragraph I will just read very at page at the bottom there is a page number below, page 18. It's a continuing. I am reading at page 19 below.
Yeah.
Page 19. At page 18, middle, that paragraph 25, which is quoted from the earlier judgment. It is disconcerting reality that temporary employees, particularly in government institutions, often face multifaceted forms of exploitation. While the foundational purpose of temporary contract may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations owed to employees. These practices manifest in several ways. Misuse of temporary labor. Employees engaged for work that is essential, recurring, and integral to the functioning of an institution are often labeled as temporary or contractual, even when their roles mirror those of regular employees. That's what I am trying to submit before your lordship. Such misclassification deprive workers of the dignity, security, and benefits that regular employees are entitled to despite performing identical tasks. So you treat me as a regular worker, you treat me as a regular man for all your jobs, for all these years before my retirement, and then say, all right, you get everything, but no pension. There has to be some rational reason behind it, As Ramanna said that every governmental action must be based on reason. And your own policies, Lord, indicate those two notifications are absolutely clear. You don't need a confirmation or anything of the kind. Your length of service, if you have served for 30 years, you are entitled to pension. That's all.
Mr. Ayub.
One thing we cannot deny, paragraph 26 is temporal justice. One line was category. Even as per the decision of this court in case of Karnataka 1, while regularizing.
You are reading from
Paragraph
frames.
So even if other facts are taken as particular, one line is general, that is the paragraph 56 of 1. The first question that should come to our mind, whether this petitioner fulfills the precondition as laid down in paragraph 56 of 1. That is the main. And so far as this guy should
No, that fulfillment criteria perhaps will be decide whether the government or in a given case why the government has not floated a scheme.
I that point of so therefore paragraph in my citation 6.6 of the paragraph 6.3.
Uday Pratap. Yes.
Not from what now
Yeah. Where are the points?
6.3.
Now, so far as the reliance, it is correct.
Okay. Yes.
In so far as the reliance is by the learned structure, depending on the reliance is in the state is it could consider the validity of the UP return to the entire service rendered as worker must not be counted for management services. That this court has observed and held that after rendering service as worker of in government, denying them the pension on the ground that they have not completed the qualifying or pension. Therefore, this court has observed and said that their service is rendered as work shall be counted or this court has not observed and said that the entire service rendered work shall be counted. This is of the of this be restricted the count of service rendered or qualified. This three line. I'm going to the other part. This three line. This decision of this court in the case of being is restricted to the counting of service rendered as work or qualified. Not any other part. Regularization and other part. Not to be regarded as a binding part. The same thing. That's the binding part.
And that is the
Smaller bench restricting a judgment of a larger bench.
In that case, definitely come to the document in that we take the earlier part. Because interpretation of the fencing judgment. In the fencing judgment, it was tried to be interpreted by the evidence that the entire worker period will be taken into account for the purpose of calculating the qualifying period. This bench says no, only the deficit part will be taken into account. It is not as stated by my learned senior that consider regular input is to be taken into account. That is not correct. The correct interpretation is that only the portion which is deficit, that part is to be taken into account, not the entire portion. That is part one. And secondly, this the other part that is not right. Because these portions not segregate whether the one part or the other part. It says the subject law category counting of service rendered as work. Only that part is to be read from the subject, not other. That is one. That is document 2023 3 as 6 equity center pathway. Paragraph 3
helpful. Okay.
paragraph 3. Paragraph 3. by order dated 18/6/2018, issued by the Office of the Chief Engineer of Liability, the claim of the appellant for regularization was rejected for the reason that both the minimum qualification of matriculation with mathematics not come in the way for its regularization. But the fact remains that the appellant was never appointed against it. Here, moreover, this appointment was never made by the company, and there were no post references at the time for it. The appellant, on the other hand, has set his claim for regularization as for who had junior as daily wages were regularized in the year 1990 or even before. The learned think that by allowing the verdict for regularization of the appellant from the date on which it junior certificate. This order was challenged by the state government authority, which allowed the appeal of the state government. The division bench rightly held that the learned single judge has not followed the principles of law as given by his state of Karnataka, as initial appointment was done by the commission, and there must be a second vote on which the daily legislative must be voted. These two conditions were clearly missing in the case of the present appellant. The division bench of the High Court therefore has to our mind rightly allowed the appeal and set aside the productive was 19. So if you are taking regularization, you have to fulfill the section. Once the section
It is emphasized on two points.
other even two conditions.
What are the three conditions? Initial appointment by competent authority.
Conditions are not for
10 years prior to the judgment.
prior to 1990. Second one is without any protection by any court or trial. And third one, working against one more that is WPC 1177. That is fact.
One.
WPC 1177.
Oh, about a good. No? 1177 of 17, 22, 8, 24, para 14, F may D. Okay, na?
Three paragraphs of 13, 14, and 15.
What? Okay, okay. Yeah.
Okay, here in this case, the wife was said to express her, it is for the purpose. Paragraph.
So essentially para 15.
Para 15, para 14 dot.
No, the ratio on the judgment is para 15.
That the principal. But one more judgment I placed there, that is third Haryana Procedural that's paragraph 13. Same.
Yeah, paragraph
13. The Honorable Supreme Court in the case of Uttar Haryana here has reflected that sentiments and sympathy alone cannot be a ground for taking judgment from what is proposed.
No, you are reading this Uttar Haryana.
Yes, no, I'm reading that WPC judgment wherein the Uttar Haryana case of
Para 13.
Yes. The Honorable Supreme Court in the case of Uttar Haryana in clear terms has reflected that sentiments and sympathy alone cannot be a ground for taking judgment from what is proposed. For ready reference, the relevant observation which has been made with a similar claim for family pension is expected here in 16. The scheme relating to transfer of family pension was made under a person be entitled to the benefit thereof, subject to the statutory from a bare perusal of the scheme in the Punjab Civil Service vis-a-vis the family pension. It would be evident that the respondent was not entitled to transfer benefit. The husband of the respondent was a worker employee. His services has never been required. It may be unfortunate that he had worked for 11 years. He expired before he could get the benefit. But sentiment alone cannot be ground for different from what. Next paragraph, paragraph. The Honorable Supreme Court in the case of State of Nagaland has also interfered with the action for effecting one-day regularization. As observed above, the direction made in the case of drafting has been held to be confined to the facts of the case as observed by the Honorable Supreme Court, the subsequent. So that is what I am expecting. Paragraph 6.3 in the Uttar Pradesh has restricted the justice of Supreme Court, binding to the effect of calculation past of
Yeah. We'll continue next week. Mr. P.K. Goswami, assisted by Mr. Kedar. Mr. P. Nayak, additionally assisted by further hearing. 20. Sorry. 15. 15th of May.
Only one word for in last case cited, my lord. There, my lord, the Uday Pratap is referred, which as your lordship has seen has again been explained by another. So I think that will lead us nowhere.
But so far as we are concerned, all three are binding.
My lord, binding to the extent of the second explanation by the subsequent judgment. It's incorrect.
The Uday Pratap is also binding.
No, that has been now eroded by the second judgment, my lord, that it is not correct. So your lordship will be bound by the later judgment.
That larger pen cannot be,
No, no.
ordinarily cannot be clarified. But
no, it is a statement strength. Both Uday Singh and the next one, two benches. Ramsang.
If it's a constitutional question, five days, that can be specific, specific of one.
Uma Devi has become also aged because so many scratches have come.
Fifteen. Yes.
Lordship wanted to see our judgments, Lordship. I have that minor son, Lordship. Pension of regarding minor son.
We'll have it on 14. 14. Into paucity of type. That was open to be listed on 14.